I've received discovery. I've received video discovery. I've 3 paper discovery. What I would like, Your Honor, in this case is a discovery order, because I want the body cams for the entire tour, for the entire shift. They give you clips of the body cams from the incident. I want the entire shift of all 3 officers that were involved in this, and that's all I need.
Mr. Sawaki?
I'll ask if they have that.
Well, I'll submit an order if I can, and if I'll submit an order to the court, and I prefer to have an order in place, so just in case something goes wrong and I don't get it, you know, it will bear on how the court rules in this particular matter, if I could.
Okay, and I would, if you all could communicate with each other in the meantime, if there are any issues, that'd be great.
Okay.
So, yep, send over the order. Let's put a date a little bit further out.
Okay.
First or second week of July.
Just a moment. I am. Would the court consider July 6th?
No, July 6th is we have a terrible docket that day. I don't think you want to be there on that day.
Okay. How about July 5th?
July 5th works, 9:30, 10 o'clock?
9:30, 10 o'clock, either one, Your Honor.
Let's do 9:30.
Okay.
Okay, and
Thank you.
30 July 5th. Okay.
All right. Talk to you soon.
Cool. Attorney McRipley, are you ready on your case?
Already, I don't have a client.
Do you want to wait for your client?
I haven't heard from him. They said it was released on tether, but he also has a second case. I don't know what status it's in, but I'm ready if you want to just send an exam date, Your Honor.
Okay. It is the people of the state of Michigan versus DeJuan LaShawn Jimerson, case 2357267. Mr. Jimerson is charged with count 1, weapons, firearms, discharge, entering the building. Count 2, weapons, firearms, possession by a felon. Count 3, assault with dangerous weapon, felonious assault. Count 4, 5, and 6, weapons, felony firearm with habitual offender fourth offense notice set for a probable cause conference today. Appearances.
Edwin Sawaki, C54828, Your Honor.
I'm sorry. Good morning, Judge Sabree. G. Whitney McRipley on behalf of Mr. Jimerson, who's not present.
Okay. And do you have discovery?
Yes, Your Honor.
Actually, Mr. Jimerson is in the waiting room.
Oh, okay. Does the court allow breakout rooms in?
Sure, yeah. As soon as he connects audio, I'll recall the matter of picture to breakout room.
Great, thank you. Does the court know who's his attorney on this other case?
I don't even have his other case. Do you have a case number?
Got a 2-3. It says 678-01.
Some numbers listed in there.
I'm
We'll look it up by name.
okay.
That's the common name. He's still connecting the audio.
Prosecutor ready on his exam at 1:30.
Yep, we're all ready. Ready to go.
All right, I'll be there.
Okay.
Judge Sabree, for the second case is for Judge Brian,
His other case was Judge Brian, who's a lawyer.
Stevenson.
Janice Stevenson.
Okay.
Okay, Mr. Jefferson, I'm gonna put you into a breakout room so you can talk to your lawyer in private, okay?
Yes.
Okay, Attorney Shabazz, are you ready or are you waiting for your client?
Good morning, Judge. I believe he should be in the waiting room, but if not, I can waive his appearance. I've spoken with him already.
He's here.
Okay.
And AG Hayes. Attorney Hayes, good morning.
Her attorney right now.
The people of the state of Michigan versus Richard Winston, 2060213. Mr. Winston is charged with count 1, controlled substance, delivery, manufacture cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance, delivery, manufacture cocaine, heroin, or another narcotic less than 50 grams, set for a probable cause conference appearances.
Edwards walking P5482.
Good morning, Judge, to you and your staff. May I please this honorable court? Justina Shabazz Davenport, P number 82743, appearing on behalf of Mr. Richard Winston, who is also present by way of Zoom. Mr. Winston, please place your name on the record. Judge, I'm not sure if he's connected to audio. If he is not connected to audio, I will ask the court to waive his appearance. I do see his name on Zoom. However, I see his video now also.
He doesn't have audio.
Okay, Judge, I will ask to waive his appearance, and I have been in communication with him. I will follow up with him to give him the dates of the exam.
Okay. You have discovery?
I do have discovery, and I see that he's now connected to audio also, Judge. I've had discovery, and I did submit a discovery order to the court, which has already been signed and turned back to me. I will submit it. I will also send it over to the prosecutor's office if I can get his email address in the chat. It's just a general discovery order. I'm asking for all body worn cameras, any audio surveillance, and scout car, dash cam, etc. Any giglio material of the officers or complaints, and things of that sort. I'm also asking for paper discovery because I'm sorry, I just habitually said I do have discovery. I actually don't have discovery, so my apologies. So I will send it over to the prosecution, and I'm going to ask for that discovery to be tendered. I will still ask for an exam date, Judge. After speaking with my client, I don't think I'll have an issue with getting discovery within the time frame.
Mr. Sawaki, was discovery sent?
No, it was not. We are tracking down the file. Some over 5 years.
Okay. All right. Of that discovery order. And does the 22nd work, or do you want a later date?
I'm going to check right now, Judge.
Mr. Winston?
Yes.
Okay, you have audio now. Can you state your name for the record, please?
Richard Winston.
Thank you.
And Judge, the 22nd does work.
Okay. Can you do 9:30?
I sure can.
Okay, Mr. Winston, your exam has been set for in-person preliminary examination for June 22nd at 9:30 a.m. at 36th District Court. You understand that?
Yes.
That means in person, okay?
Okay.
All right, and I'm also going to follow up with you, Mr. Winston, as well. I'm going to give you a call.
Okay. Thank you.
But the one she was out here.
Thank you, Judge.
You're welcome. Have a good rest of the day.
You all as well. Take care.
Ready on Jimerson?
Y'all ready, huh?
Okay, we're back on the record on Dewan Jefferson. Attorney McRipley, you had an opportunity to speak to your client.
Yes, Sean, we still requesting an exam date.
Can you do June 22nd as well?
No, Your Honor.
Okay. I'm out that next week without coverage, so I'll be in, the next date will be July. Are we open July? Are we?
I do believe Judge.
July 3rd will be the next day.
They told me my next court date was June 22nd.
Yeah, okay, sir, just, I need you to be quiet for a second while we get your date.
July 3rd is fine.
July 3rd?
Yes, Your Honor.
Okay, 9 o'clock?
Yes, Your Honor.
Okay. Mr. Jimerson, your date has been changed to July 3rd at 9 o'clock a.m. for exam. You understand? You have to unmute your device, Mr. Jimerson.
Yes, that's a whole 30-something days from my what's the name? My 14-day what's the name to have a examination.
Well, your attorney, if you were listening, said he wasn't available on the 22nd of June. Did you hear him?
No, I am available. I have another lawyer that I have. I have someone who's available for the 22nd. I just had to give me another lawyer because with my work schedule and everything, I can't keep prolonging and stuff. This tether is stopping me from being able to work the 4 hours I'm able to work.
If you hire another lawyer, you're still gonna have to wait till the 22nd to have a probable cause conference. And then after that, we can schedule it there. So if you hire a lawyer, you're not gonna be able to handle that matter today.
So how am I able to have a conference down there 30 days from preliminary?
Did you discuss any?
No, I can say it again.
You discussed it?
I'm sorry about that. It was. Can you say that one more time? It's my
I
phone.
said, did you discuss any?
No, definitely not.
I'm not about to go back and forth with you, Mr. Jefferson. Your date has been set. If you want to hire another lawyer, you can do so, and he'll file his appearance if you hire him. But as of now, your date has been set for July 3rd.
Okay.
Thank you, Your Honor.
You're welcome. You all have a good day.
See you this afternoon.
All right. James Paul, what is your first and last name, sir? With the green sweatshirt, the green hoodie on, what's your name?
Jermaine Cooks.
Mr. Cook. Okay, you're a lawyer.
Yeah, I don't see him in here.
Oh, okay, he already logged on. He set your exam date for July 5th at 9:30. That'd be in person at 36th District Court.
July 3rd?
No, July
July 5th? Okay,
at 9:30, 36th District Court in person, okay?
thank you.
You're welcome. Okay, Attorney Bobby,
Good morning, Your Honor.
morning, what's going on?
Not much. We have Michael Ajami. It's a waiver of an exam, and Mr. Hayes is on also.
Okay.
Should be, sure, I didn't take your bag.
Okay, this is case 2255746, people of the state of Michigan versus Muhammad Yusuf Ajami, charged with count 1 gambling activities, felony violations, count 2 gambling activities, felony violations, as well as count 3, same count, set for an exam today. Appearances,
Good morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people, P69006.
And good morning, Your Honor. Hassan Bazi, P78448, on behalf of Mr. Ajami, who is present via Zoom. Mr. Ajami, state your name for the record, please.
Good morning, Your Honor. It's Mohammed Ajami.
Judge, today, time for sentencing. At this time, I had a chance to talk to my client. We freely volunteer waive the rights to an exam and ask us to be bound over to circuit court.
Okay, Mr. Ajami,
Yes, Your Honor.
I'm going to ask you some questions. If you can't hear me, if you don't understand, let me know, okay?
Okay.
And before I begin, Attorney Hayes, no objection from the people for a waiver?
No, Your Honor, thank you.
Okay. Mr. Ajami, you understand you have a statutory right to a preliminary exam?
Yes, Your Honor.
And that if you were to demand that exam today, the people would have to show the probable cause standard, which is a much lower standard in criminal law, but still a standard, that all of those charges I read off were committed in the city of Detroit and that you committed those crimes. Do you understand that?
Yes, Your Honor.
And that by waiving your exam today, that means that people do not have to present any evidence at the probable cause standard today or at any time. Do you understand?
Yes, Your Honor.
And knowing that information, you still wish to waive your exam?
Yes, Your Honor.
You also understand that you are not giving up your right to trial.
Yes, Your Honor.
Did anyone force you or threaten you to waive your exam?
No, Your Honor.
Did anyone promise you anything?
No, Your Honor.
Okay, I find waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, for an arraignment on the information date 2 weeks from today of June 29th at 9:00 a.m. For everyone on this case, do I have your permission to sign the waiver form since everyone is virtual?
Yes, Your Honor.
Yes, Your Honor. You said June 29th, Your Honor?
Yes, June 29th.
All right, thank you.
Anything else? Either party?
No, thank you, Your Honor. Have a great day.
No, thank you, Your Honor. Have a good day to your staff.
Thank you.
Thank you, Your Honor.
You're welcome. Have a good day.
Bye.
June 29th. Attorney Culpepper? Oh, you're on mute.
Yeah. Hello?
Yes, good morning.
Good morning, Your Honor. Your Honor, I have an exam scheduled tomorrow for Matthew Gunn. I have received the police discovery. I've even received some of the video, but I've subpoenaed the poll cam in the area, and that won't be ready for some more days.
What is your client's name?
Matthew Gunn, G-U-N. I think I'm set for like 10:30 tomorrow morning.
10 o'clock, okay, I see. Okay, how much time do you think it's gonna take to get that video?
Well, I'm away next week, so I'm thinking, is there any more space on that July 5?
Yes.
Whatever slot you can give me on that day, I'll take, Your Honor.
Okay. How about 10 o'clock?
Sounds like a plan. I appreciate it.
All right. July 5th.
Thank you, Kat.
Let's say 10.
I'll inform Mr. Gunn. Thank you.
Okay, thank you. Yeah. We're done tomorrow. We all let the witnesses know.
Yeah.
You got it. Okay. Anybody present for Michelle Justice?
Yes, Judge, I'm ready.
Okay. Okay, this is case 2357288. The people of the state of Michigan versus Michelle Renee Justice. Ms. Justice is charged with one count of police officer assaulting, resisting, and obstructing set for a probable cause conference. Their appearances.
Edwin Sawaki, P5482A, appearing on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Service by Summers Brush, P number 85828, appearing on behalf of Michelle Justice, who is present via Zoom today. Ms. Justice, please state your name for the record.
State your name, Ms. Justice. I didn't hear you. Okay, for some reason I can't hear her, but I see that she can hear us. Okay, Attorney Brush, you have, Summers Brush, you have discovery?
Yes, we have both paper and digital discovery. So we are ready to set this for an in-person preliminary examination.
Yes. So I have June 22nd available, and after that, it'll be July 3rd as the earliest date.
Let's do June 22nd then.
Okay, 11:30.
That works perfectly.
Okay. Ms. Justice? I know you.
Yes.
You can hear us. Oh, there we go. So your exam has been set for an in-person preliminary examination for June 22nd at 11:30 a.m. in person at 36th District Court. You understand?
You said June 22nd?
Yes, so it'll be next year.
Okay.
All right, anything else from either party?
No, Your Honor.
No, Your Honor. Thank you.
Okay. Attorney Elijah.
Good morning, Your Honor.
Who are you here for today?
I'm here for Audrey Akins. Ms. Akins is in custody, but I would waive her presence if you want to go forward with the PCC.
Yes, please. 2356976, people said Michigan versus Audrey Maria Akins. Akins is charged with count 1, 4th-degree arson with the habitual offender fourth offense notice set for a probable cause conference. Appearances.
Edwin Sawaki, P5482A, appearing on behalf of the people.
And Emily Elijah, P85039, on behalf of Ms. Akins. Ms. Akins is in custody, but I would ask the court to waive her presence. I have had communication with her, obviously.
Okay, I will waive her presence. Do you have discovery?
Judge, I have partial discovery. I have paper discovery and I have surveillance video. I do not have any body cam video, in-car video, or other footage referenced in the paper discovery. I did send to the court a proposed discovery order this morning, ceasing Mr. Silwaki.
Mr. Sawaki?
I will check into the body cam in the car. Yes, you can. Video.
I was going to offer the date of the 22nd for an exam. Do you all think you need more time?
Unfortunately, Judge, I am out of the office on the 22nd. I did hear the court say the next available is the week of July 3rd. I can do July 5th if that's a good date for the court still.
Yes, it is.
And I have open availability for whatever time works for the court.
How about 10:30?
That will work, thank you. And there's one other matter I'd like to address.
Sure.
Ms. Akins is in custody on a probation hold out of Frank Murphy. So she was given a personal bond here with a tether, but she is in custody anyway. I'd ask the court to impose a nominal bond of $50 so that she can earn credit on this matter should it move forward post-exam.
Any objection from the people?
No, Your Honor.
I'll make it $10.
Thank you, Judge.
Okay, I'll send over that order today.
Thank you, and I will see you on July 5th. Have a good rest of your day.
You too. Thank you.
We're ready, Your Honor. Would you like me to get my client?
Boy, he about to go in there.
Frank Demont Grady, good morning.
Good morning, Your Honor. How are you?
Fine, how are you doing?
I'm well, thank you. I'm on Terry Thomas and out of custody PCC.
Okay. Attorney Cox, I just want you to know, the attorney for the co-defendant hasn't logged in yet. That's why I haven't called your case yet.
Oh,
Judge,
I see him there.
Yeah,
I'm here.
Okay, I have down as Attorney Barrett.
That was for the other co-defendant. There's 3 co-defendants.
Well, thank you for that. Okay.
I am ready too. Thank you. It's going to be a waiver.
Okay. Okay, let me handle this in the courtroom and then I can handle that matter. And Ms. Akins, I will call your matter. I see you have you checked in. Give us a moment.
Okay.
Okay, this is case 2356900, people of State of Michigan versus Davion Cheatham. Charged with 1 count of assault with dangerous weapon, felonious assault, set for an exam today. Appearances.
Alexander Kirker on behalf of the people, P86282. Good morning, Your Honor. Curtis Davenport, P82678, on behalf of Mr. Davion Cheatham, who is present to my right.
State your name, sir.
Davion Taiwan LaRue Cheatham.
Morning. Okay, is everyone ready to move forward?
People are not, Your Honor, are necessary witnesses not present. You would ask to move for dismissal.
Okay. Without prejudice, as the people are not ready to move forward, time is 9:13. Exam is set for 9 o'clock. I will have the discovery. The dismissal order signed shortly.
Thank you. Can I get that email to you as well? Sure. Thank you. Everyone have a good day.
Mr. Cheatham, what's your birthday?
My birthday, October 13, 2008. Yes.
Ms. Akins?
Yes, good morning.
Good morning. Your lawyer just logged on and handled your matter. All we did was set your exam date today. So your preliminary examination date has been set for July 5th at 10:30 a.m.
Okay, is that all you need me for today, ma'am?
I didn't hear you. Say that again.
Is that all you need me for today? I can go back now?
Yes, you're on the probation hold, right? In custody on another matter?
Remanded or something?
Okay, so I also adjusted your bond so that you can get credit for time served on this case in the event that you do have to serve time. So your lawyer did address that. So it was a personal bond. I put it at $10 so that you could receive credit for time served on the case with my court.
$10?
$10, yes.
Okay, so what do I have to do to be released, or is that I don't understand?
So your lawyer can probably explain it better to you, but it's to help you out. So right now, it doesn't matter because you're on hold on another case, you're remanded on another case. So when you're on a personal bond on a second case, you don't get credit for time served. So your lawyer asked to put an amount on this case so that you can get credit for time served in the event that you have to serve some time later down the road on this case. So if you end up pleading guilty and have to do 30 days in the Wayne County Jail, you will get credit for that time because your bond was set at a dollar amount versus a personal bond. That makes sense?
Yes, ma'am. Thank you.
You're all set, your exam is set for July 5th at 10:30 in person, and I'll have you brought over.
In person?
Yes, in person.
And Frank Murphy's?
Yep, Frank Murphy Hall. No, 36 District Court.
Okay,
District Court.
okay. Okay, thank you. Have a good day.
You too. Thank you.
Bye-bye.
Bye.
Okay, I'm trying to get to, corporate environment here. What's your name? What do you mean?
Turn up.
Here, corporate too.
At first was Wade, she Wade, and then Jordan. That's the old one, I didn't know.
She had King.
She has
Right.
King or something.
Okay. All right, let's handle Simpson and you're all set, Ms. Akins. You're good for today.
Thank you. I'm just waiting on the officer to come get me.
Okay, all right. Jimmy Hanash and Andre Simpson.
And I think, Your Honor, Terry Wayne Thomas is their person. Yeah. No.
This is Brown Gray. So we don't have.
My mistake.
Oh, no, you're fine. Where is? Attorney Haisha, where is your client?
Judge, I was gonna waive his presence. We're just continuing to exam today.
Oh, okay, all right. 2357092, people of the state of Michigan versus Jimmy Hanash, who is defendant number 1, and Andre Lamont Simpson, who is defendant number 3. Defendant number 1 is charged with count 1, organized retail crime. Defendant 1 is also charged with count 2, weapons, felony firearms. Defendant 3, Mr. Simpson is charged with count 6, stolen property, receiving and concealing a motor vehicle, as well as count 7, organized retail crime. And Mr. is also charged with count 8, stolen property, receiving and concealing $1,000 or more, but less than $20,000. And Mr. 3 also has an official offender 4th offense notice set for a probable cause conference today. Appearances.
Edwin Sawaki, P54828, appearing on behalf of the people.
And Judge Vincent Haisha, P76506, appearing on behalf of Mr. Hanash, who is not present and whose presence I would ask the court to waive.
I will waive his presence.
And good morning, Your Honor. May it please this most honorable court, Nicole Casca, P55470, on behalf of Mr. Simpson. Mr. Simpson and I are present on Zoom. Mr. Simpson, please state your full name for the record.
Good morning to the court. My name is Andre Lamont Simpson, Jr.
Good morning, sir. Okay, let's start with Mr. Simpson. Is it correct that Mr. Simpson will be waiving his exam today?
Judge, that is correct. I've had an opportunity to discuss this case with Mr. Simpson, review the discovery. At this time, I've advised him of his constitutional rights, statutory rights, as well as the maximum penalties that he's facing. After all of our discussions, including about the nature and purpose of a preliminary examination hearing that we have set for next week, my client wishes to freely and voluntarily and knowingly waive his right to a preliminary examination hearing and proceed over to circuit court where the case will remain there. Thank you.
Thank you, Attorney Casper. You did it for me. I don't have to go through it. Mr. Simpson, is all of that true that your attorney just stated?
Yes, ma'am. Yes, Your Honor.
Don't force you or threaten you to waive your exam?
Yes, ma'am.
Wait, did anyone threaten you or force you to waive your exam?
Oh, no, no, ma'am.
Okay, did anyone promise you anything?
No, no, ma'am.
All right, by your waiver to be freely, understandingly, and voluntarily made, and I will have you bound over to 3rd Circuit Court, Frank Murphy Hall of Justice, for an arraignment on the information date of June 29th, 9:00 a.m. Mr. Simpson and Attorney Casper, do I have your permission to sign the waiver form since you are virtual?
Yes, ma'am.
Yes, you do, Judge. Thank you.
You're welcome. Anything else for Mr. Simpson's case?
Just bond be continued.
Bond is continued.
Thank you, everybody.
Well,
Mr. Simpson, do you want to address the court through your lawyer?
well, we have my lawyer. I'll just speak to my lawyer.
Okay. All right. You have a good day.
Okay,
Right.
thank you. We can log off, Mr. Simpson.
And for Mr. Hanash, we have an exam set for June 22nd, 9:00 a.m.
That still works, Judge, unless that date's bad for the court. I could do the July 3rd date as well. I'll leave it to the court's discretion.
No, let's get it over with.
Thanks, Judge. We'll see you then.
Right, have a good one.
You as well.
Thanks. Okay. Okay, Attorney Demonte.
Yes, I'm here.
Terry Thomas. Okay. Case 2357256, the people of the state of Michigan versus Terry Dwayne Thomas. Mr. Thomas is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. And Mr. Thomas, it should be noted, is defendant number 1. And that is all he is charged with, except for a probable cause conflict of appearances.
Alexander Turner on behalf of the people, P86282.
And good morning, Neighborhood Defender Service by Kate DeMont Grady, P83667 on behalf of Mr. Terry Thomas. Mr. Thomas is out of custody. The phone number provided on the assignment is not functional. I've asked my investigator to assist me in contacting Mr. Thomas. So at this point, I would ask the court to waive his presence, the understanding that I just, or the representation I just made.
Okay, I'll waive his presence.
Thank you. Your Honor, I have received both paper and digital discovery, and we're requesting a preliminary examination date.
How about June 22nd at 11:30?
That works for me.
Okay. See you then. Have a good rest of your day.
You as well. Thank you.
All right, early. Good morning. Okay, we're on the record. This is case 2357125, the people of the state of Michigan versus Charles versus Martin. Mr. Martin is charged with count 1, controlled substances, possession, cocaine, heroin, or another narcotic less than 45 grams. Count 2, police officer assaulting, resisting, and obstructing with individual printed forth witness notice, except for example.
Edwin Suwalki, P54828, appearing on behalf of the people.
Good morning, Your Honor. Attorney CR438 appearing on behalf of Mr. Charles Martin.
And there's no Mr. Martin present.
No, Your Honor. This morning, defense has made an attempt to contact Mr. Martin. I haven't been able to get hold of him personally, but I was able to speak with his significant other, girlfriend, Nancy, who said that he periodically and very consistently checks himself into substance abuse programs. And she gave me a list of 3 different places that I'm gonna have my investigator call to check to see if he can tell at any of these facilities. So at this moment in time, Your Honor, we're asking for an adjournment of the preliminary examination.
Anything from the people?
No, Your Honor, we don't have a problem, especially if it's
Do you have any clue where he is? Which one?
I have lists, I have names, I have like Common Grace, Lighthouse, and there's another one, I can't remember off the top of my head.
I don't want to set this for another exam date with no indication that he'll either be found or show up. What is your date? This will be the first one. Once you try it, if you do, you want me to go to court. It'll be 1,000 first. Anything else?
Nothing further from the defense. All right, thank you. Everyone, gotta go on next.
Thank you too.
My partner did. That's a big here in the OIC.
Okay.
They're brothers.
Yeah,
in here. I have my screen up.
Mr. Thomas?
Yes, ma'am.
Hey, sir. Your court date was at 8:30 this morning.
Oh, I'm sorry.
Your lawyer logged on and handled your matter for you.
I'm sorry. I'm sorry to cut you off. They never placed the time on the sheet that I was given.
It's always on there typically, but it doesn't matter. I'm gonna give you a next court date, and you can contact the lawyer. You have your lawyer's information?
No, can I receive it?
Yeah, give me a second.
Okay.
Oh, Mr. Buckner?
Yes.
I think in your message, you have paperwork saying you have court today?
Yeah, on my personal bond slip, it said I had court on the 9th and the 15th.
Let me look your name. Hold on. Yeah.
All right, I'll see y'all later. Yeah, on the next one. Yeah, take care. Have a good one.
Let's see. What type of case is it?
My case?
Yeah.
Obstruction arrest, I think that's what it was.
Police officer obstructing or resisting?
Yes, ma'am.
What's your middle name?
Liddell.
You have a case number in front of you?
No, it's not even on this paper.
What does the paper say?
It's the personal bond paper, the paper they give you when you get out the 36th district. They'll tell you what the virtual to go on and everything.
Okay, I'm gonna have to have the clerk double check, because I don't see anything in here for you.
Okay. So do that mean I just still report to court in person on the 20th?
It says Judge Sabree
Yes, ma'am.
on the 20th. Let me see if I can find you on the docket. Yep, 9:15.
Okay. Thank you.
You're welcome.
All right.
The defender's office is asked her number, please did not bring, so I got her. Terry Thomas.
Oh, yeah.
They had the court set.
Got it. I'm like,
Mr. Thomas,
Yes.
your attorney is Miss Attorney Demont Grady. And her phone number is 313-418-9304.
Okay, thank you.
What's the next court date?
Sir, and your next court date is in person on June 22nd at 11:30 a.m. at 36th District Court.
Okay.
Okay.
Good morning.
Good morning, Your Honor. Yeah.
Good morning, everyone.
Good morning.
Are you ready on the motion for Michael? Is it McCreary?
Yep.
All right, the clerk can call the case.
2356485, the people of the state of Michigan versus Carnell Michael McCreary. Mr. McCreary is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, 9, and 10, weapons, felony firearm. With the habitual offender fourth offense notice set for a preliminary examination today. Before the exam, there was a motion that was filed by Mr. McCreary to disqualify me from this case, and that is why Chief Judge Conoco is on Zoom to address that motion.
Okay, appearances.
Edwin Sawaki, P5482A, appearing on behalf of the people.
Carnell Michael McCreary, natural person, not a corporation, natural flesh and blood.
Okay, thank you. Thank you for your appearances. The court did receive a motion to disqualify Judge Aliyah Sabree pursuant to MCR 2.003. The court, having considered the pleading and being otherwise fully advised on the premises, the defendant having moved to disqualify Judge Sabree, but having stated no grounds that meet the legal basis under MCR 2.003 that would demonstrate that the judge has shown actual bias against the defendant or defendant's attorney. It is ordered that the motion to disqualify Judge Sabree is denied. This order does not resolve all pending claims as to the remaining parties and does not close this case. So the motion is denied. Thank you very much.
And Attorney Washington, I know you want to put your appearance.
Oh, yeah, I'm sorry. Yes, Earl Washington as the backup attorney.
May I speak, Judge?
That matter.
Now that matter is resolved now. The court is turned over back to, excuse me, sir. The motion was denied. And now the court is being turned back over to Judge Sabree to handle the preliminary examination. Thank you very much.
Well, can I at least place my objections on the record?
It's been noted.
I mean, I'm just saying
Mr.
because
McCreary,
I thought you were the chief.
Mr. McCreary, your objection has been noted.
May I address the court?
Not on that matter. I can't hear a motion to disqualify. According to Michigan Court Rule 2.003, the chief judge has to address it in a multiple.
But that's not how the rule.
Multiple judge court. This is a multiple judge court. Chief Judge Conoco just addressed it. You received your motion in writing and he responded on the record and he denied it. There could be no more discussion from me about the disqualification motion, Mr. McCreary. It's been denied.
But can I just address something? I mean,
it's already been addressed in your pleadings and I cannot respond. I don't know if you understand. I can't respond regarding the disqualification.
I'm not trying to do that. What I was saying per the rule, due process.
You're still talking about something that has nothing to do with.
Well, I object and it's on the record.
Yes, and I've noted that. So as far as the exam, the time is now 10:17. Are you ready to move forward with your preliminary examination?
I came here today with intent, like.
Yes or no?
No, I'm not prepared because of this. I mean, I would like, you won't let me speak, Judge. Like,
I
you give
know
him a
you
fair
speak
chance
in regards to what I'm
to
asking.
respond, but you won't give me a fair chance to say or speak.
Mr.
I mean,
McCreary, I let you stand here for 45 minutes last time we were here talking to you, didn't have anything else to say. So today I'm asking you, are you ready to move forward with your exam?
No, I'm not. I would like to call witnesses.
Based on what?
Pardon?
Based on what?
Because my intent as today, this motion was filed, the court was supposed to deny it because I thought you were the chief judge pro tem. And per the motion, it says that if you were the chief judge pro tem, it's supposed to go to the state court administrator. This gentleman here, I'm not familiar. Like first,
You're still addressing the motion to disqualify.
My due process is being
violated. And it's not.
I mean, you won't let me tell you
why. It seems as if you can read it right. The court rules are very clear about motion to disqualify. There's no black, it's black and white. So, Mr. McCreary has been denied.
Okay, we understand
And if
that.
you knew that, it also says that there's the timing in which the court can address that can be any time. So you knew you need to move forward with your exam today.
Well, what I'm saying is I have a right under 6.110 to call witnesses.
Yes, you
Things of
do.
that nature.
And why aren't you prepared today?
Because you won't let me speak.
I didn't know. I said, why aren't you prepared today?
I'm trying to tell you.
Today's your exam date.
Can I respond? You keep cutting me off, Judge.
You're not answering my question.
I'm not prepared because when I filed this court was supposed to make a ruling. Then if you denied it, it was supposed to go to the chief judge.
No,
That is the
I can
process.
tell you no. It's not.
That's why I'm not.
I can't deny a motion to disqualify in a multiple judge court.
Can I pull up the
Read the
rules?
court rules, 2.003.
I'm familiar with it very well.
We're not that
In
familiar.
Crampton versus Michigan Department of State,
You
said
can
even if
state
you
any
can't
case
show
law you
bias.
want in a multiple judge court. I cannot handle your motion that you filed. It goes to the chief judge. Chief judge, I am chief judge pro tem, two different things. I cannot handle my own motion to disqualify. That would be bias, Mr. McCreary. So do you have witnesses to be there?
You won't let me respond.
Yes or
Judge.
no?
No, I don't.
Okay.
Because my intentions, as I stated, under this
It's just a
rule.
yes or no. I just want to know.
I
So you
mean,
can finish looking under court rule 2.0.
Why am I not being allowed to address the court and give it a fair exchange like
I'm
the
asking you
prosecutor's
questions. This is not your courtroom.
office?
I'm asking
I'm
you.
not trying to disrespect
I have
this court,
given you
Judge.
all the leeway up until this point.
I mean, the law
Today's
gives
the
me
exam
rights.
date. Go ahead and check your court rules. Get back to me. Are the people ready to proceed?
People are ready to proceed, Your Honor.
And I object, I'm not ready. Because, I mean, I would like to address the record for preservation rights. So far as I have to go to the
You
higher
want to
court.
research 2.003 first, because that seems to be what you were stuck on. I want you to go ahead and
I
find
mean,
that
there's
first.
Michigan case laws, but Judge.
Court rule 2.003. Go ahead and find it. Tell me where it says that I'm supposed to address it.
Okay, section B, who may raise, the party may raise the issue of a judge's disqualification by motion, or the judge may raise it, excuse me. C, disqualification of judge is warranted for reasons that include but are not limited to the following. The judge is biased or prejudiced for or against a party or an attorney. B, the judge based on an objective and
Those are the
reasonable.
grounds. You gotta get to procedure.
All right.
Section D.
Oh, my goodness.
Three. A. Start there. I can read it for you. 2.003 D3 under ruling.
I mean, I was getting down here.
In
You
a
say
court having
B3?
2 or more judges, on the request of a party, the challenged judge shall refer the motion to the chief judge, who shall decide the motion to no. That's right. The written order that will be provided to you stating the time. So, Mr. McCreary, I am ready to move forward with the people's witnesses.
Well, I have evidence, I mean, since you're forced to compel it, which violates my rights under UCC 1-3. Also, I'd like to make a non-pro time. Again, motion to challenge the jurisdiction of the court. After this, the hearing we had last, I believe it was what, the 30th, I believe it was. The prosecutor gave me 15 pages and he attested on the record, 15 pages all they had. There's no warning. There's no signature signing off for the prosecutor to initiate charges, whatever else. I mean, this whole case, I object to this case being moved forward under Brady violation, Fourth Amendment violation. I mean, they're committing crimes here in this courtroom, and this judge, you're allowing this.
Nothing has been presented to me.
I mean, I'm just saying.
I'm talking. Stop talking over me. You've been doing this since you've been in this courtroom. Every time you talk, I let you finish, whether it means it's meritless or not. I haven't heard anything of any substance or any value worth me addressing when it comes to Brady violations. So I'm ready to move forward. And if you want to call witnesses, and we have to hold in part because you didn't subpoena them today, we'll address that when it comes time after the people rest. So Attorney Washington, is there anything you'd like to put on the record before we begin?
No, Your Honor.
Okay. Any preliminary matters from either side regarding the exam?
Preliminary matters, yes.
People have to address the court first.
Yes, Your Honor, people have exhibit 1, which I will show to the defendant and his, Mr. Washington here. It is a register of action certified, case number 98007-861-01-FH. It indicates that, defendant, Mr. McCrary, pled no contendere, assault with intent to maim, would like this as people with exhibit 1.
Oh, he said, I was found guilty. Assault with intent to maim. Hold on, he said I was convicted of that?
Under what court, under what statute?
Oh, I'm sorry, Your Honor.
I object, I wasn't convicted.
MCL 766, 11B, 1B.
I object to that, Judge. I was not convicted of that. Matter of fact, Judge Dawney Robeson was a visiting court. And again, this gentleman is lying to the court. He just lied to the court. That's perfect.
And you had the opportunity to review the document?
Well, he said that I was convicted of assault with intent to maim. Can I ask that what you said?
I said, you pled no.
No. I wasn't found.
Mr. McCrary, you review the document first?
Yeah. Okay, but what does this got to do with the case? Robbery not armed, and assault with intent to maim. I have the transcripts at home. And the court order from Judge, he was a visiting Judge Dawney Robeson. Matter of fact, in that case, Your Honor, the prosecutor, what was this, Thomas Beadle, I believe his name was, he said that the officer in this case lost his entire file.
Can I see the?
And I have this transcript at home. How you gonna speak on someone you lost a file? This case was the felonies was. It was a misdemeanor, aggravated assault. And that's the case that, because in the transcript that I have at home, I would like to make that an evidence after this is concluded or whenever I can. Because he's just lied to this court, Your Honor. That's perjury committed in court, Your Honor.
Okay, I have a seal here from the register of action sealed from the Wayne County Clerk's office stating that you pled no contest to
That's inaccurate.
assault with intent to maim.
That's inaccurate, Your Honor. I had a transcript at home.
Can you let me finish what I have to say, please? The jury trial was held in front of Judge Roberson. You were sentenced and committed to Wayne County Jail. Your sentencing on September 8th, 2000. That's it. So for exam purposes, under MCL 766.11B1B, exam purposes only. This satisfies with you can place your objection on the record.
Well, I would like to say, because in this case, I have the transcripts at home. And I object because this man just lied to the court, because in this case, that Thomas Beadle was supposed to be the special prosecutor. They held me there for 2 years. And he stated on the record, there's no support for this case. The officer in charge lost the entire file. So how are you going to present a register of actions? That's not evidence, Your Honor. I have the evidence at home. And I would like to object to this, and I would ask that you hold him in contempt of court for committing perjury.
I'm gonna hold you in contempt of court in a minute. You keep talking over me. So I'm going to admit as exhibit 1 over the objection of defense as a certified copy from the clerk's office for exam purposes only, showing that Mr. McCrary was convicted of felon intent to maim in 2000. Anything else for preliminary matters?
Not from the people, Your Honor.
Okay.
Also, Judge, I would like to make a motion to sequester, because my intention is to call the chief detective on the stand, because
Okay. You don't have to tell me a theory.
Matt?
I will do it.
Okay.
So let me do that first. So if there's a potential witnesses on this case, now is your time to log off. As far as in the courtroom, if there's anyone present who may testify on this case, maybe a witness, now's your time to exit the courtroom. What's next?
Per the court rule, I'm allowed to admit evidence for evidentiary purposes of impeachment under People versus Stanaway. I also would like to address to the court, Kim Worthy, I believe it was last year, put a witness list out for officers who have previously testified falsely in court proceedings, that they couldn't testify in future proceedings. My brother, Norman McCreary, has committed perjury in front of Chief Judge, Wayne County Chief Judge Freddie G. Burton. He committed forgery as well as identity theft. Also, I have affidavits from my other brothers where they've been trying to press charges. I tried to press charges. And the prosecutor and them not doing anything. Also,
let me address that first.
Yes.
So, Mr. McCray, if your brother testifies, you can definitely cross-examine him, impeach him, and bring all of that out. And if the prosecutor objects, we'll address it then. But you can do that on purpose.
I need to get y'all copies.
No, I don't receive copies until you introduce it and it's provided to the court. I don't do any preliminary impeachment. So once you cross him, if it comes out that he was convicted of a certain crime under the court rules or under evidence that allows you to discuss it, then that's your right to do so. Next.
I would just like, he was not convicted, but he was in the courtroom. It was established by the Chief Judge Freddie G. Burton. And my other brothers were kept in the mind all these years, and they're trying to come forward. And I have an affidavit on my phone from my brother that's notarized. He's in the state of Florida. And
the brother that's testifying
no,
today?
my brother Charles at 50.
So you have to address your brother today when you cross-examine, okay?
Also, again, I would like to renew my motion to have the prosecutor's office withdrawn because of criminal misconduct, conflict of interest. My former attorney works for Kim Worthy as the director of the wrongful convictions unit, Valerie Newman, and it is quite well documented that Kim Worthy, as well as my former attorney, committed felonies. And it's all a matter of public record. And, you know, for this gentleman here to come here and try to mislead the court, I believe it's under 3.3 of the Michigan Rules of Professional Conduct. It states once an attorney knows, I believe it is, that they have told the court something, they must correct it. And this prosecutor is committing misconduct because I have from a stenographer transcript at home, in which I would like to.
You know the avenue to do that. If you want to report misconduct, you already know that. So let's get started with the exam. I've heard all of your motions and you place it on the record, and you will of course order the transcript to be able to move forward to the next steps that you want to do. So any other preliminary matters to address regarding the exam today?
Well, how about, I'm just saying this, the recusal aspect.
I'm going to deny that.
Well, can I place my objection?
Absolutely. I hear your objection. Everyone else does. Ready to call your first witness?
Yes, I am, Your Honor.
Mr. McCray, do you want to sit at the table up here?
I will ask that the police officer be called first because we have to establish how he investigated and other things that nature.
Now that would be you working for the prosecutor's office. You don't get to tell them how to try their case.
No, I'm not saying that. What I'm saying is I want to question them as the investigation.
Okay, and if the prosecutor, are you going to address their request or call who you said you're gonna call?
I have one witness.
Okay, so in this case, he gets to
Well,
start with
can I
however he wants
call
to.
as a witness, being that he's trying to bring my brother? I would like to
So
establish.
procedurally, prosecutor has the burden of proof. You should know that. So
Well,
they have to go first. They have the burden here.
well, they have no
And then
evidence,
you
Your
can
Honor.
call
for the-
witnesses if you like to. If
Yeah.
you feel necessary, you can do that. We'll discuss that after the legal rest, okay?
Yeah, they have no evidence, Judge.
You don't know what they have.
They just say it's in the paperwork.
I'd like you to stay focused, okay? And the first thing we're gonna do is hear testimony from the people's first witness. That they have a burden. So please, call your
People call Norman McCrary.
Standing, raise your hand. Raise your right hand.
That microphone, when you're talking, you can put that in your lap. Okay, Mr. Sawaki, whenever you are ready.
Sir, could you state your name for the record, please?
Norman Leon McCrary.
And what brings you to court today?
The incident that happened on the 9th, and I was leaving the house after another incident that happened inside the house.
Okay.
And I went to my next door neighbors.
Okay. Let me back you up a little bit there. Was that February 9th this year?
Yes.
Yes, and did that?
Objection leading.
Piece of paper.
No, I have some. Objection, he's leading the witness, Your Honor.
I think, sorry, go ahead.
Because he said no.
One witness testified that it was night. I was merely clearing up the aspect of which the 9th of the month it was. or which month it was.
Objection, it's still leading.
Okay, this is, I'm going to overrule on that because of the preliminary matters as far as date and time. And we get date tonight, and I believe this is clarification, not to leave. Go ahead and get her.
Was February 9th, correct, of this year?
Yeah.
Okay, and then, what address did that occur?
14739 Homer, Detroit, Michigan.
And, that's in the county.
Yes, my county.
Because all the COs work together. Now, you had, confrontation, right?
Yes, if that's what you want, yes, confrontation, we talked after
Okay. Who did you have the confrontation?
Colonel McCrary, sitting right there.
Could you,
Objection, Your Honor, I would like to also, there was one single photo lineup, which he seen my picture prior to this exam, it was a photo lineup, single. And this is how, you know what I mean, he's my brother, true, there's a procedure on the due process. Oh, okay. Yes, I would like. I mean, I'm good, but I would like to object because there was a suggested photo lineup used. If you look at this discovery, it says that a single photo was shown to Mr. McCrary. And this violates, what is it, United States versus Wade, I believe it is.
It would be way to address that. However, Mr. McCrary, that's fine. It's very delicate for you to represent yourself. You just stated that he's your brother.
I mean, but it's still a procedure, Your Honor, that has to be followed.
I mean, this is one of the most easiest identification cases. If he knows you as your brother, he can identify you from that day.
But it's still, it's suggested, it violates the law.
We're not even getting to the line at this point.
Well, I'll place my objection.
I hear you. So, Mr. Sawaki, please continue with your questioning.
could you describe a piece of clothing that, the gentleman?
He has a blue jean jacket that I had.
You know, let the record reflect that, witness has identified the defendant.
It's not reflected.
What, at this address, you arrived at it, you had a confrontation. Could you go more into that?
Well, prior to seeing my brother Carnell, I had went into the house the day before on the 8th, and the downstairs door, which is the part that I had, was kicked in and damaged. So, and then I went into the back room, and the second door was kicked in and damaged. Objection, Your Honor, he just committed perjury. The first door is not kicked in, it speaks of.
Sir.
Oh, okay, I'm sorry, I didn't know I had to say it, I'm sorry.
What you're doing is you're testifying as to what happened. All you can do in this case, if you're saying that he's not telling the truth, is on cross-examination, you have the opportunity to question him and possibly raise issues of credibility. But that at this time, you're testifying as to what happened and not objection regarding the rules of evidence, okay? Every objection has been placed.
I understand this, man. And if I may finish, upon going into the kitchen.
Second. Describe this house, is there like, is it apartments?
It's an income bungalow. So it's an upstairs and a downstairs, and they're separate, and they both have separate utilities. And the downstairs is the part of the domicile that, I was, having, I became executor of the estate. So, I kept the house so that my other siblings, including him, could stay there.
Okay.
So I came downstairs.
Say no, who are you referring to?
Cornell McCreary. So when I came downstairs.
Just so the record's clear, whose estate are you talking about?
My deceased mother's estate, Mamie McCreary.
Who lived up? Did someone live up in the?
Cornell McCreary stayed upstairs after he was released from prison.
Okay. So you came in and there was damage?
Yes, there was damage to the front door, the kitchen door, and a bedroom door.
Okay. What happened?
Okay, so
This is on the 8th.
yeah, so I didn't have a camera with me at that time to take pictures of the damaged property. So I came back on the 9th, and then once I came back on the 9th, I took pictures of the damages that were, incurred in the house.
What, after you took your pictures, what did you do next?
I left the house and then I went next door to one of our neighbors she had fell sick and she had a pacemaker. So, she grew up, we grew up with her. She's like a mother. Okay. So I went next door and, visited her. And then upon leaving, when I was coming out, my brother was coming, Colonel.
Okay, you were coming out of the neighbor's house. Where was your brother coming out?
He was coming out of 1417 home.
Okay, and that's where he lives. Correct.
He lives in the income bungalow upstairs.
Okay. What happened when you got it?
He confronted me and, I told him, I said, so is this how you're gonna do our mother's house? And he was, he started talking about taxes, which he hasn't paid, So, and then I was like, man, I tried to ignore him. So he's like, so you going to go to the police on me and all this kind of stuff. So, and, I was like, yeah, I'm going to the police. And he's like, well, somebody's gonna die today, me, you, or the police.
Okay.
So, and then I ignored him and I went to my automobile.
Okay.
And I was about to get into our automobile. He picked up.
When you got into your automobile, what happened next?
He picked the brick up and hit the car with the brick. Okay. So I jumped out of the automobile and, ran after him and he ran. So, I was like, man.
Okay. Where did he run?
He ran up on the porch of 1417 home.
Okay. You sit tight, Your Honor. When you ran up, when he's on the porch, what did you do?
I went, I ignored him and went back to the car because I was gonna go and file a police report.
Okay. And when you went back to your car, what happened next?
He picked the brick up again and hit the car again. So now this time I ran after him again and he ran up onto the porch, opened the door, and then came outside with a semi-automatic weapon and fired into the air twice.
Okay. He fired it twice.
Yes.
And then what did he do?
And then
I'm sorry, did you say into the air?
yes, into the air twice. And then he looked at me in the eyes and then pointed the weapon at me and shot in my direction. And,
Okay. When he shot in your direction, where did the bullet go?
It's a field right across the street from the house. So I can't say where it went, but it went in that direction towards the field.
Well, what did that do to you as far as?
I was, first of all, I was upset that my brother would do something of that nature. Then, I kind of feared for my life, so I jumped into the vehicle and drove off.
And you said the weapon was, what type of weapon again?
It looks like it was a rifle, it was a black, it could have been an AK.
But you're not sure, right?
No, I'm not sure.
Okay. And after you got in your car,
I was really upset, and I went directly to the precinct and I filed a report.
okay.
And
I have nothing further for this witness at this time, Your Honor.
Ross, does that make sense?
yes, I mean,
And Mr. McCray, and just want to let you know, you are bound by the rules of evidence. If the prosecutor objects, if you need any help with it, Mr. Washington is there. Okay?
how you doing there, Norman McCurry? I'm here. You all right today? Okay, let me direct you. You stated that I shot in the air. Is that correct? That's correct. Okay, isn't it also correct that you said I shot in the ground as well? I didn't see you shooting the ground. Well, no, I'm just saying, is it just a no? Did you say I shot in the ground? I didn't see you shooting at the ground. Okay. Your Honor, yes or no? I would like to reflect for the record that at another proceeding, the prosecutor stated that he said that I shot in the ground, shot in the air, and shot him in 3 stories. Okay.
Your Honor, I don't recall that, and today we have to go by testimony of the witness, that's what we're here.
Well, you were disposed before, sir. You're
I represent the people,
representing. Okay, that's all right. Okay, you spoke about a probate issue, am I correct that you were the executor, sir? Yes, I did. Okay, isn't it true, have you ever committed perjury, or have you ever committed forgery or anything that nature? Oh, Your Honor, you just lied. Here's the paperwork, this impeachment with, isn't it true that you forged, my name? What does this have to do with? Well, it's impeachment, sir. It's impeachment, sir. People versus Sandway laws, the rules of evidence. Isn't it true that you forged my name, David McCurry, Norman Paul McCurry, James McCurry, and Charles McCurry? That is not true. Okay, I have affidavits from him notarized where he stated that the brothers gave him permission to sign individuals' names, and the judge issued a show cause hearing. Give me a second, please. Okay, here we go. Here's an affidavit I would like to get a copy of to the prosecutor's office. It's signed and notarized by Norman McCurry. And this is allowed for impeachment purposes. He just committed perjury on the stand, Judge. And on page 2, Norman said that the other brothers, Charles, James, and Paul McCurry, agreed to getting the loan, the signing of their names. Oh, okay, yes. Could you, I'd like to give it to your witness and see it too. You just lied on those, sir. And it's signed and notarized by him in the probate, Wayne County probate proceeding. That was forged by the judge. It was not, and I had to follow the judge. He committed perjury. And I have an affidavit from my brother on the phone too, that he didn't give me permission as well. And I'd like to have, that's what I was saying about witness call judge.
That one.
Your Honor, this is just an affidavit. It doesn't show anything about perjury. And not only that, but
it's forgery, sir.
1 second, Mr. McCray, one at a time.
in order, the court rule, in order to be impeached, it has to be conviction. Therefore, I'm gonna object to this line of questioning unless the defendant can show that the witness was actually convicted.
Where is that case law? Show me the authority by that, that's why.
The court rule.
The Michigan rules of evidence
Judge,
allow for.
He just lied under oath, and he lied under oath in the courtroom.
For
That's
you,
why I don't like this
Mr.
opinion.
McCrary, let me finish addressing the objection. Under the Michigan rules of evidence, to attack someone's credibility and to impeach them, you have to do it under whether or not the witness has been convicted of a crime involving dishonesty, false statement, or theft. If there's no proof of a conviction, I'm not sure how you plan on proving that with an affidavit that has not been verified by anyone, no court other than an affidavit signed by another person who's not here to testify.
This is affidavit. This is what I'm saying, it's signed and notarized, Judge. And then I was also previously, I had transfers where I impeached police officers in Wayne County from complaints about them, and the judge allowed me. I just asked him, did he ever forge anybody's names or whatever else?
He said no.
And he said no. And the affidavit shows that he said my other brothers agreed. I have affidavits from Charles McCurry and other people that say they didn't give him permission. This is a felony. This is a crime, Judge. How can you allow this gentleman to come in here?
You have to file a police report for that crime.
I tried to.
Well, I can't.
They ignore, there's vindictive second prosecution, Your Honor.
I'm not allowing you to present an affidavit. There's no conviction of the three things: dishonesty, falsehood.
Okay, can you show me in the rules of evidence where that is? It says about convictions. Because other courts, I remember, I can't think of the chief judge from '99. He was here. He allowed.
1999.
Yes, Capers P. Harper was my attorney at the time. There was a deputy sheriff named Clifton Needed. And we asked for additional discovery to impeach him. And the judge allowed it at the time. I have this document at home as well. This is for purposes of impeachment. He just lied and said he never forged nobody's signature. And that doesn't equate to conviction or not. I have affidavits saying that, yes, he forged my signature, he committed felonies, and he did what he did. And this is his affidavit of truth.
Saying that he committed felonies?
It shows that he said.
Yes or no? Does it say he committed felonies?
Yeah, right here. It says that Charles and them agreed for him to sign their names. My brother has an affidavit saying that he did.
That's not saying I committed felonies.
Forgery is a felony.
I know it is. So
Identity
is lying,
theft
so is shooting
and
people,
perjury.
so telling people you're gonna kill them, so is murder. There are a lot of crimes.
So that's discrimination on your part
If it
because
hasn't
you're
been
allowing me
proven or
saying.
established, then what do you expect me to do?
Well, I have the affidavit showing this contradicting what he's saying per my witness,
For the rules.
Charles McCreary, and I would like to admit that in evidence as well. Because he's saying that he didn't forge these people's names, and my other brother's saying that he did. And this for purpose.
Michigan rules of evidence.
And can you give me the rule?
609.
609, okay.
609.
Go here. You just lied under oath this time. MRE 609.
For purposes of attacking the credibility of a witness, evidence that the witness has been convicted of a crime shall not be admitted unless the evidence has been elicited from the witness or established by the public record finished during cross-examination, and the crime contained an element of dishonesty or false statement, or the crime contained an element of theft, and the crime was punishable by imprisonment in excess of 1 year or death under the law under which the witness was convicted. So the issue here is that there was no conviction. So
Okay.
I'm not admitting that evidence.
Can I
Move on to the next question.
give you, speak about the rule?
I'm denying objection. You just say that you, disagree and object to my sustaining the objection.
Yes, I do object, and this goes also, again, I would like to renew my motion to recuse under People versus Crampton, Michigan Department of State, Crampton versus Michigan Department of State, Kane versus MBOC, because this court is being biased, and there's previous proceedings where the court allowed these types. Yeah, under in this court in
I didn't
'99.
do that.
Well, what I'm saying is I asked him a question. He said, no, I have evidence to show he did.
I have evidence under
And
Michigan
it
Rules of
involved-
Evidence 609 that allow for you to establish that. Next question, Mr. McCreary.
Okay, now here you just spoke on the rule, and I would like to argue the rule. It says unless solicited, I solicited from him and then dealt with theft and dishonest crime. And this court, I feel, is being biased toward the prosecutor.
You're sounding like a broken record. I heard you already.
All right.
Denied.
Okay. Can I continue? And I object again.
Please.
Mr. McCurry, isn't it true that you consider yourself a sovereign citizen?
Does that have to do with this case?
Well, it's relevant. It's relevant. goes toward credibility impeachments, Your Honor.
I object to the relevancy of the question.
It goes to the credibility of the witness and to test his credibility.
So stop.
People versus sound.
Mr. McCreary, the case law, you can stop right now. Rules of evidence. How is this relevant to the case here today, whether he's a sovereign citizen? And don't say anything about dishonesty, because you are too, and you've
How am
established
I
that.
being dishonest?
I said, don't say that it's about dishonesty, because you've stated that you're a sovereign as well.
I mean, yeah, I agree.
So what is the relevance
I'm not
of
the straw
him being a
man.
sovereign today while
I'm
he's
not
testifying?
the straw man. What I'm saying is,
Answer the question. How is it relevant that he's a sovereign citizen?
because he's the same person that fights you guys. In court, he's issued, I'm indigenous to this land, where you sit and say.
Both of you all, in a minute, in this exam, it's gonna be some contempt hearing going on, if you all don't stop. I don't care if he's a sovereign citizen or not. That has nothing to do with the case here today. So I don't find it to be relevant. So next question.
So you stated that I shot in the ear, is that correct? Yes. Okay, you also stated that I shot at you as well? Yes. Okay, is there any witnesses to this? And what time was this about?
Well, I can't remember this young man's name, but him and his mother was outside.
Okay, so what time was this?
I can't remember.
You can't recall. Does the people have this information, Judge, if he doesn't know the time that this occurred? Because on this day, I was at work.
It was
I was at work in Oak Park.
It was around probably after 5.
You just said you didn't know, Mr.
Well, I said I don't remember, but if I try to recollect, then I would say I get off work at 4:30, so it had to be after 5.
Okay, are you familiar, do you recall that I worked at Glory Supermarket in Oak Park?
I don't know, I didn't know where you were. You very
Okay, now let me ask you this, for your birthday, didn't I get you 2 bottles of rosé for your birthday? And I told you about I got a cheap.
Objection.
Well, no, I'm trying to establish that he knows that where I worked at. This is what
I knew that you had got a job, but yes, you
at a
did.
supermarket.
Yes, you
Okay.
did.
To the McCreary's. When there's an objection on the floor, everyone should stop talking.
Thank you.
For a couple reasons. The court reporter, you are torturing her right now because she cannot take down anything when everyone's talking. So please, one at a time. There's an objection on either side. Stop talking. So there's an objection. What is your objection?
Relevancy.
What is the relevance of the 2 bottles of
Well,
rosé?
to establish that he knew where I worked at, so that I can let it be known that I was at work during this time that he claims whatever this stuff is going on.
Okay, even if he doesn't know where you worked on that day and time.
Okay, this is what I'm
It's not
trying to.
relevant as to the day and time in which you were at work.
Well, the time of the crime that he stated, I mean, how do you not know what time the crime was? You saying the date, but what time?
I'm talking about where you worked, or the time.
Well,
of day.
what I'm
Because he
trying to-
said after 5, it had to be after 5, because he works until 4:30. He doesn't know the exact time. Is that my understanding of what he said? Is that correct?
Well, I worked afternoon.
Is that correct, what he just said?
Pardon?
He said after 5, because he gets done work at 4:30. Not sure what time, but somewhere after 4:30, after 5. Is that correct?
I mean, this is what he stated.
That's all I want you to say. We all agree on what was said. Okay, so he doesn't know the exact time. I understand. Next question is, how is the 2 bottles of rosé relevant to the day of the
Well,
event?
the reason that I stated that, Judge, is because he knew where I was. I was telling him about how cheap things were there with my employee discount. So he just stated he didn't know where I work, but he knows where I work. Because I gave him 2 articles from the job for his birthday.
Okay.
And then, I have witnesses, that I would like to call in, Robert Van Dyner,
Okay, you
Gerald
can call that
Flowers,
when
and
it's
other
time for you
people.
to roll it.
Yes, because Mr. McCreary, was paid money. This is why he's.
Mr. McCreary.
Okay.
Last
All right,
question
let me-
for
okay.
examination.
Mr. McCreary, isn't it true that you allowed Mr. Robert Van Dyner and Gerald Flowers to rent the downstairs at some
I'm
point?
gonna object to relevancy.
Well, I'm trying to establish, that Mr. McCreary is committing crimes, past and present. This is what this is about for purposes of impeachment.
No, for impeachment, you have, I read the rule, 609. Unless you have some other route, you asking questions about
Well, the thing is, he's stealing money. If you look at the taxes, like the taxes is still in my
And
mind.
guess what?
After
Even
10 years,
if
20
he
years.
was stealing money, it wouldn't be relevant today during this testimony.
So he can steal from me and that's okay. And other people, it's okay.
No, it's not okay.
And I've made reports, and the 10th precinct is retaliating because I made reports against their officials down here to failure to protect.
You are
Judge.
muddying the water, not staying focused on what has been charged on this case.
Well, I'm being denied my rights. This is what I.
So I am going to sustain the objection, it's not relevant. Question.
Okay, isn't it true, Norman McCurry, that the taxes mainly McCurry are still in her name after 20 years of being the city servant?
Yeah.
No, it's this your witnesses committed felonies and you're committing felonies with them. You and Kim work.
Okay.
And there is documented. I'm just this purpose of
It's
it.
just this, well,
The purpose of it.
okay. Okay, next question.
May I ask you a question? How did you come to work here to court? How did you get here? Did you drive or were you brought?
Objection, Your Honor, relevancy.
Relevancy is Mr. McCurry is driving. He has no license. And
Okay,
he's
are you
breaking-
just trying to
he's breaking-
tattletale on him for
No,
everything
I'm
he does all
impeaching.
day?
He's breaking laws, but I'm being accused. I'm innocent.
Okay,
I'm innocent,
it's still not
Judge.
relevant to the allegations and to what he testified to on direct examination.
Well, if I may respond, the relevancy is that Kim Worthy has executed things against police officers, but the witnesses are being allowed to commit perjury and get on the stand. This violates the officer's right, equal protection clause of the 14th Amendment. Because if officers have testified or lied and they weren't convicted,
What does the officer have to do with anything right now?
well, this is the witness.
He's not an officer.
He's a witness though. It's just,
It's not
if
the
you,
same. This was a very specific case. We have specific testimony. I don't care if he has a license or not. So sustain.
well, what I'm saying is,
I don't care if he has a license or not.
well, the police and him, they're being allowed to commit felonies, but I'm here to be accused. And this is,
You
I'm
have
trying
been
to
accused.
establish,
You're not being accused. You have it.
okay, I'm being accused. I have been accused, yes,
next
and there's no evidence. Mr. McCurry, can I ask you a question? Did you know that there is no evidence in this case?
Objection.
Why?
How would he, he's not an officer.
Well, I'm just saying, there's no evidence.
And actually, there is evidence.
Where is this here?
Your Honor, his testimony is evidence.
That's not
That's the
evidence under Opera versus United States.
Under the mission rules of evidence, testimony is evidence. Next question.
Okay, may I object under Opera versus United States, testimony without cooperative evidence is not evidence.
Yes,
Jackson
so
versus Virginia,
That
and wait.
is incorrect. Next question.
I just say I'm being lynched today by this court as well as my brother.
Is this your closing argument? Because you can say that.
Well, I mean, you won't let me bring nothing in. You're shooting down everything that I brought in because of judicial bias.
It's not
Other
accurate
courts have
under the
called it
Michigan
relevant.
court rules of evidence, under the Michigan court rules, under the rules of evidence. So I'm not lynching you. I'm denying you certain things that you're doing because it's not applicable and proper in court.
All right, now may I respond to the rules of evidence, statement that you
No,
made,
you can
Judge?
ask the next question that's relevant to the exam you're taking.
Well, I mean, I can't ask everything. You shoot down everything I bring it, Judge, and I
If you don't have
object.
any more questions on cross, then you can say no more questions. Have a seat. If you don't have anything
I'm
that's
being
relevant
denied.
to the direct test, the direct evidence that was provided, or the testimony on direct.
Well, may I address something that you stated, Judge, if I may?
Question to the witness.
I mean, I just yield because I'm being denied my rights and I object to this whole proceeding because I'm denied to present evidence and call witnesses on my behalf.
No, you haven't been
To
denied.
properly
The people haven't
cross-examine,
requested for you to
to
even
properly
present
cross-examine the
any
witness. And then they're charging me with strangulation. It says injuries. No, this man is not hurt. He hasn't been shot. They got weapons and strangulation. I do all this to women. It's that wrong. This is what I'm trying to
You weren't
understand.
charged with strangulation.
Yes, it's in here.
It says or by strangulation.
Okay, what's the first part?
It's called with the 50 grade level.
Okay, assault with intent to grave bodily harm. He has not been hit. He hasn't been hurt. He hasn't been anything happened to him. Where's the medical report?
So we'll get to that in the argument. carefully. You'll learn elements of
I
that.
mean, I just object and I rest and I'll leave it to the circuit court as
But you
well
can't
as.
rest, you haven't even had an opportunity
Well,
to
I'm just
present
saying
witnesses. Do you have any
because,
more questions of the witness?
I mean, I'm being denied my right
Yes,
to properly
or
cross-examine.
no? Do you have any more questions of the witness?
Oh, no, because I'm denied the right to properly cross-examine.
Any redirect?
No redirect, Your Honor. People have no further questions.
Mr. McCreary, do you have any witnesses?
I would like to call the chief officer that's the investigator on this case, and I also object to him not calling any other witnesses at this juncture because there's a witness list. And I would like all witnesses to be brought here so that I may properly examine and cross-examine these witnesses because they don't have a warrant, judge. Like after we had the hearing when he attested to court, I just had 15 pages. This is all that we have. Where's the warrant, judge? How am I charged? Where are magistrate's signature?
So as far as, this is the probable cause here. This is not, let me finish. This is not trial, okay? So the people do not have to present anything but what is the show probable cause, not beyond a reasonable doubt. So if they want to call one witness, they can. You want to call the officer in charge on the case?
Well, can I call all the policemen that are on the list? Since he's not calling them?
You need to offer of proof.
Pardon?
Offer of proof as to why you need to call them.
Well, because their investigation. This is what I want to question them as to their investigation. How now the law is, I cannot be tried for a crime that I haven't been charged with. There has to be a complaint, warrant, and a request for a warrant, and there's not anything here. How was I even charged, judge? And there's no warrant.
So.
And out of the 15 pages, I looked, and that's a violation of the Fourth Amendment to the U.S. Constitution, judge.
Great. You said you wanted to call the officer in charge?
Yes, the officer in charge.
Okay.
And the other officers.
Now, I will allow for the officer in charge because he's here, correct, Mr. Walkie?
Correct.
Okay. For the rest of them, you did not subpoena or bring anyone today.
Well, I didn't know he was not going to put them on here. They're
It's
on
not
the
his
list.
job to call your witnesses.
No, what I'm saying is they're on his list as witnesses, and I would like to basically get the court to
He
have
did
a
not
clear
provide a
understanding.
witness list for an exam.
It's a
In
list here.
discovery and investigation report, I believe, is that what you're referring to?
Yeah, right here, the prosecutor's office witness list. I have a right to this.
Okay,
And I
so
would like to cross.
you have a right to interview them and subpoena them to come to court.
Well, to
And you ask
establish.
the people to make them available to interview also before.
Yeah, I understand.
Okay, today we're here.
Well, in the
And-
6.10, it says I have a right to examine, cross-examine the witnesses of the prosecutor as well as myself.
You do.
And they had an investigation. I would like the court to have a clear understanding so these charges can or cannot be established properly under the due process.
I will allow you to call any witnesses that you have subpoenaed and that are here today, as well as the people's witness who is officer in charge on this case who is also.
Man.
Call that.
Oh, yes, but man, I object to the court's denial of my Sixth Amendment right to call witnesses and also in the MCR 6.110. Because to establish a proper investigation, this court to be full aware of what is going on with this case and evidence concerning this case. I mean, these officers have to be brought forward so that we can ask them how they did the investigation.
And I believe that is the manner that you may, if it gets bound over, you can address at trial. There were several motions. It's the proper cause here, Mr. McCreary, very minimal.
Well, I mean, the rules are clear and under due process,
They
the
don't seem
statute
to
of
be
due
clear
process.
because you still talking.
Well, may I address the court? I mean, you give him the full rights to speak, but I'm always cut off.
Well, it's because you're saying things that really aren't relevant. So the officer in charge is here. Do you want to call that person to stand?
I definitely will.
Step up to the court reporter, give her your name and spelling.
You swear to tell the truth, no truth, and nothing but the truth.
Yes, Your Honor.
And sit down to make sure you speak up in the mic. Whenever you're ready, Mr. McCreary.
Can you give me
like this, sir?
pardon? I hear you. Can you give me your name and badge number for the record, sir?
Officer Edward Pulowski, -4753.
You say Pulowski. Okay, so you're the officer in charge,
Yes.
detective? Okay. On the day in question, what time did Norman McQuarrie come into your station to make? If I'm
I don't know the exact time, it's even right at the incident.
right after this, then, so you didn't take the initiative to write down what time he came in here? He came into your office?
Your Honor, I'm gonna, check the foundation. It hasn't been established that this witness actually took the report from the witness.
Okay, so where's that?
Let's clarify that.
Okay, I would like.
Lay a little bit of foundation as to
Well,
what
if
he's involved in.
If he's the head officer. Okay.
Lay a little foundation, which means ask questions about his involvement to get to the fact that you're questioning whether he knew what time.
I understand.
Right.
Okay, did you, are you the only one that had contact with Mr. McQuarrie?
No.
Okay, may you tell me whom Mr. McQuarrie started having contact with, in the beginning?
The officer Clannon who was working the desk.
Officer Clannon. Clannon?
Clannon.
Oh, Clinton, okay.
Clannon.
Okay. So you took the report, or Officer Clannon took?
Officer Clannon took the report.
Okay, and this is the report that's in this file that I may, this report here, sir?
You wanna,
I mean, I'm just asking, is this the report that the
I don't
officer
know,
took?
can you see that report?
That's not a report, so that is a written statement.
Or a written statement?
Yes.
Well, it says in the interview, like, it's questions are asked, and then the officer is writing the questions, then he's writing the
I'm
answers.
gonna, Jack, because it hasn't been established that this witness has taken that.
Well, he's the chief officer in charge of the state, so everything falls on him, just like you're supporting of Kim work, sir.
No.
Everything you do falls on her.
What are you trying to establish?
Well, I'm trying to establish time, place, and things of that nature. I mean, there is allegations.
Let's take the very specific question you're trying to establish with this statement, what?
Well, I'm trying to establish a time frame. When did he come into the office? When did he speak?
Okay.
Who did he speak with? What time reports were made? You know, to clarify everything Mr. Norman McQuarrie stated.
Okay.
So I'm trying to lay a foundation as to this investigation.
Okay, and if that's not the document that the witness has prepared or is familiar with, because if he didn't prepare that, then you can't present that to him to tell him to refresh his memory or recollection about it.
Well, I was just asking what time did Norman come in to make a report?
And your response was you weren't sure.
He said he don't know, so.
Yes, I mean, this is one of probably 300 cases I've had since then. I don't remember the time of every case that I had. It's all in the reports, which is public record.
Okay, so do you have the report?
Well, talking about for this report here, yes.
The witness just stated that he's not sure what time, but it's in the report. You have that report that he's referring to.
It says, I can't understand this reading. I mean, can you understand this?
just
I mean,
but-
5, it says end time.
Don't read to me on.
Oh, it
anything on
says
the-
start time is 5.
Mr. McQuarrie, when I read to me what's in the document, do you have it?
I have a police report, yes.
Okay,
I believe he still has a statement. If it's written pen, it's a statement. The report is all typed.
Well, this was taken on the 10th, Your Honor, the day after the fact that I was.
you have your report or your investigator's report?
It's all in the jacket. There's an investigative report, there's the police reports, there's everything, the warrant.
I don't have a warrant. Where? It's not in here, Judge. He said he gave me 15 pages and he attested this is all he had of last proceeding. There's no warrant here. There's no authorization from the prosecutor here. And then if he pulls anything else out, that's a Brady violation.
And you may have it. What is showing?
It's not here.
You don't even know what he's about to show you.
What I have that was in the packet, discovery packet, is the Troy Police request for a warrant, investigative report. It starts on page 3 and appears to go through page 6.
The actual report you just had.
And this is even signed by the prosecutor, where they recommend or deny a warrant request. This is not even signed, it's not notarized, these documents are not
Okay, let's
legible.
stick to, do you want to present that report to refresh his recollection about the time?
Well, no, I was asking him.
But that was the line of
No,
questioning.
that was not where I was trying to go. Where I was trying to go, I was asking him to get a basis. He stated that Mr. McCurry, my brother, came into the police department and made a report. This report showed that he gave a statement on the 10th, so how it happened on the 9th? He said he went in there on the 9th, and this is written on the 10th.
That would be the day after. This is you testifying, first of all. There's been no testimony that anyone came on text.
Okay, well, look, I'm just saying he's objecting to everything, and I have foundation and the right to ask these questions.
Ask about that.
Okay, so you stated that you're the chief officer in charge of this case, am I correct?
I'm the officer in charge, yes.
So you just stated under oath that you didn't know what time that Mr. McCurry came to the police precinct to make a complaint.
Not the exact time, no, sir.
Okay. Here, I would like to impeach him. Did you guys seek a warrant from Kim Worthy's office on this day in question or at any time?
I don't remember what date I sent it exactly, but yes, we sent, we tried to back it over to that prosecutor's office.
Okay, at your, what's the word I'm gonna use? At your direction, did you order your officers to arrest me on the date in question, which when I was brought in for this case?
I didn't tell them exactly what day to arrest you. Once we do any kind of felony case, I gave them to our special operations unit who works out the 10th precinct. I know that there's probable cause to arrest somebody. If they come across somebody, they'll lock them up on that case, yes.
Okay, was there a warrant, sir?
Not at that time, no.
Oh, is there a warrant now?
There should be, because you're reporting.
No, sir. Right here, Judge, I would like to amend the evidence where right here, this is the Wayne County prosecutor recommendation. It's blank. It's blank. Now, my paperwork is supposed to be the same as his.
Your Honor, it is blank. The only thing that's different is that it's been redacted with the witness's address between his and ours. And that's perfectly legal, and that's to protect the witnesses unless there's a special.
You talking about the warrant, sir? Not the protection.
I'm explaining why the difference.
I'm not a threat to him.
So.
And it's the last page of investigator's report, that's not going to be an actual warrant, that's set in with every investigator's report. The authorized warrant is going to be the black and white with all the charges.
Okay, can I ask you a warrant where?
So there is an information.
The objection, that's not signed, notarized, or approved by court, the court rule.
That would be a motion that you can address if this gets found out regarding the warrant.
Right. Well, I would like to continue my cross-examination if I may, Judge.
Please.
How long have you been an officer? Officer Pulowski, you said it is?
Yes. In Detroit, over 7 years.
Over 7 years. Oh, you've been a police officer in another city?
Right.
May I ask where?
City of Westland.
City of Westland. And you say you've been in Detroit how long now?
7 years.
Are you familiar with the restrictions of the Fourth Amendment to the U.S. Constitution, Article 1, Section 11 of the Michigan Constitution, sir?
I just put for a record that the officer isn't an attorney.
Well, but he's supposed to be a law enforcement officer. How you gonna be a law enforcement?
No, you don't.
Yeah, I know about the Fourth Amendment, yes.
Okay, again, was there a warrant when you arrested me?
I did not arrest you.
Well, your officers, you should know what your officers are doing. Notice the agents, notice the principal. notice the
Question, what's the
principal, notice
question?
agent. Okay, did your officers have a warrant when they arrested?
No.
Judge, I move for dismissal at this juncture because there's nothing authorized by the prosecutor or anyone else. And he just stated he arrested me without a warrant. This is a crime. I would like to state this. In 2001, the Department of Justice indicted DPD for dragnet arrest.
Okay.
And this
So
violates the
I'm
Fourth
denying that request. You can be arrested without a warrant.
Can you show me the law where that is?
No, it's not my job to show you that.
Okay, well, I'm saying under federal case law and state case law under Article 111 of the Michigan Constitution of 1963, as well as U.S. Constitutional Amendment 4, enforced upon us, the states, they have to have a warrant, Judge.
32 hours.
72 hours.
Charged.
Well,
at some point, I don't know,
Mhm.
but that's once again outside of the purview of this exam
Well,
today.
they're committing felonies, Judge. This is the
Okay, and I am not the police department,
Okay.
I'm not the FBI,
May I
I'm not the
continue?
Department of Justice.
Okay.
The charges here today are assault with intent to murder, assault with intent to do great bodily harm, less than murder, or by strangulation, weapons, firearms, possession by a felon, weapons, ammunition, possession by a felon, assault with a dangerous weapon, felonious assault, and also 4 counts of weapons and firearms.
Okay. Give me a second. Okay, do you have any video evidence of when Mr. McCreary came into the station, like body cams, which are mandated by law? So far as the desk officer, or you giving the interview, are these articles available?
There is no body cam footage on the front desk. It was all recorded at the station.
Okay, within the station, why haven't you put that evidence into discovery so that the people could have it? Sir.
If anything's requested from inside the station, it can be put in there, yes.
Okay. I'm looking for this page. Okay. May I take you to, I believe it's page 6, Detroit Police request for warrant before you was off, please, sir?
I don't take anything, I'm not supposed to take anything.
You don't have anything, okay. Can I get the court officer to hand this to the gentleman so I may question him about this discovery investigation? Okay.
Last page.
No,
Of
I would like that back, but I would like to ask him a question when it concerns that.
so you want it back, or do you want him?
No, I want him to look at it and I want to question him about it. But once he's done with, I'm going to be questioning him. I would like that back, paper back. That's all. Okay. Okay, you see the part right there where it says evidence officer. Can you tell me what that says?
None.
None. So how did you move forward if there was no evidence, Your Honor?
Mr. McCreary, you established what it is to be.
Oh, okay, that's the, can you read that for the record, sir, at the top of the page?
Well, actually, you would have to ask some questions.
Oh, okay. Can I see yours, Mr. Prosecutor? What do you guys ask that?
Yeah, sure.
Okay, you have in your hand what's called a Detroit Police request for a warrant, am I correct?
Right.
Okay, on the top part it says admissions and confessions, what does it say?
None.
Okay, lineups, what does it say?
Single photo lineup showing Mr. McCreary.
Okay, evidence?
None.
Okay, and then you have the witnesses, then it says video, and you tell me what that says, sir.
Body worn camera footage not available due to the report being taken at the desk.
Okay, and photo?
None.
Okay. So is this typically how the 10th precinct operates? No warrants, no evidence, they prosecute individual citizens? Is this how this happens, sir?
So when I submit one of these.
That's a question, sir. I'm asking the question.
Yes, this is typically what ours looks like when we send it in.
No, what I'm saying is this the procedure or the custom that your agency uses when they prosecute citizens so far as no evidence, no warrants? I'm saying, is this a policy or a custom with your department, 10th precinct, sir?
What policy just?
No, I'm saying that the operating of procedures so far as handling of investigations, prosecuting citizens when they're accused of crimes. Is this how you typically handle cases with no evidence, no warrants? You go get people. I mean, is this typically how your department runs?
Every case is different, sir.
Okay. Have you done this in your past history in Warren as well as Detroit, Michigan? Do you have a history of this, sir?
Sending it down warrants, yes, I have history.
Without evidence and without arresting people without warrants. This is what I'm saying. Do you have a history of arresting people without warrants or evidence, sir? This is the question.
I'm gonna object because
If
he's
so,
not,
Let him finish the objection.
he's already, the witness has already testified that he did not arrest him.
Or have a warrant at the time.
well, what I was, Judge, what I'm trying to establish.
You're trying to establish way more than
Well,
what's needed for this exam.
well,
This
what-
is a whole, holistic type of approach you're trying to have here with the police department, Jim Worthy, the bench, I understand that, but as far as this case, if you're not getting to specifics about what he did, he's not even seem to be that involved into what
Well,
happened.
what I'm saying is that like right now, you had a chief judge that just heard my motion to deny me because they're your supervisor. He's the supervisor of these officers. They move at his direction. If they don't move at his direction, that means they're vigilantes, Judge. They're just doing what they want to
In
do.
your opinion.
I mean,
So
it's-
what is your next question?
Well, my question is, does he have a history of arresting and charging innocent citizens without warrants and without evidence. And I know I
What's your
have.
answer?
No.
Next
Okay,
question.
I would like, okay, now to establish that he's telling the truth, I would like to file a motion for the discovery under MCR 6.201, which allows this to his background history of complaints for false arrests or things of that nature. And I have transcripts before where this has already been approved in other court proceedings. And I would like to, at this juncture, subpoena his background history as to Warren as well as to Detroit, because if he has done this today to me, he has done this to many other individuals. And I would like the procedural and the substantive due process protection in this proceeding and the equal protection of the law of the 14th Amendment. Judge.
I'm denying that request. I know you like to object. Please object to the record so we can move on.
Judge, I mean, okay, now, like I already placed my objection, I'm being denied my rights to a fair trial.
It's not a trial. That's
I mean, not my trial. Well, this is a hearing. Well, I'm still entitled to my rights in the hearing.
Cause hearing. It's not guaranteed by the Constitution. It's a statutory right.
Well, if there's a federal right, we have two different things, with all respect to the court.
And I'm sure mine is right when it comes to whether or not you have a constitutional right to an exam and whether it's statutory.
All right, I'm ready with my question. Okay, so are you familiar with the law in Michigan so far as state statutes, state laws, and things of that nature? Do you have some form of did you receive some form of legal training when it concerns your job? You went to the academy back in the day.
Yes.
Okay. Did you know under MCL 750.505 misconduct offers that is a 5-year felony that you have committed against me, sir, based on lack of evidence and no warrant, sir?
I'm gonna object.
Well, the objection is not founded, prosecutor.
Let us know what is, I don't even know what's objection.
Relevancy, defendants testifying, he's accusing of crimes.
Argumentative.
Argumentative.
I
So the question just doesn't make sense.
Can I respond, please? Sure. I mean, it goes for purposes of impeachment, Judge. And then, like I was stating, Kwame Kilpatrick was sent to prison for the same thing that he's doing. And I mean, he was the mayor.
You're not about to convince me anything,
Yes, ma'am.
mentioning Kwame Kilpatrick's conviction, so.
All right, well, I mean, can he answer my question? I mean, if he's a law enforcement officer, he should have no problem answering questions. of
Well,
the
it's
law.
not relevant.
Well, it's relevant because he's committed a felony, Judge.
That's an accusation.
This
It has
is-
not been presented to the court in any matter other than you telling him that he committed.
Well, can I, again, ask this court on the MCR 6.201 Brady versus Maryland, request his background history for purposes of impeachment at People versus Stanaway, which allows.
More discovery?
Yes, I would like to, have more discovery so far as impeaching his witness
So
because,
just if this is found over, I will sign discovery order.
well, I'm just saying is I need it for purposes of the exam under MCR 6.110 to properly, cross
Discovery is
examine.
an ongoing, it's ongoing.
Well-
So today, the exam, we're in the middle of it. We've got plenty of time to prepare for this day. If it gets found over, I will sign discovery order and you can request.
Well,
Okay.
yes, ma'am. Under People versus State, again, I say that citation I will have today here in court where Judge Rosen dismissed a case against the prosecutor as a sanction for withholding evidence. He knew that his witnesses would be here, then he didn't.
Agree. That's an argument that you can discuss during the argument once you're ready.
So he's not allowed to answer the question that I asked him so far. So,
No, I'm just saying.
okay. Are you familiar with Mr. McCurry or your department, the 10th precinct at all? Have you ever had any knowledge of him coming to your department or complaining about your department or anything to that nature?
For this case, I never had any contact.
Okay, are you familiar with the Sergeant Ball that worked at your organization?
Yes.
Okay,
Wait 1 second, sir. Is it the one that's retired or the sergeant?
He's retired.
Okay, because there's two balls there, the sergeants at some point, I just want to make sure I have the right one.
yes.
Okay.
Okay, so when you did your investigation, how did you come about knowledge of McCurry beside with his brother? How did you know how Mr. McCurry looked? What information did you find out where he lived? Did you do a lien check? Did you check the system for pictures or addresses? Did you do any of that, sir?
So typically when I get a case, it pops up, we call it our hopper. It's where it lists all of our cases down for the day. I make my initial calls, try to make contact with victims, and get them in for another written statement, because sometimes we get a police run, people's minds are elsewhere, or they don't ask the right questions. I might need more for my investigation. So I get them to come in, either me or someone else who might be used. I'll get a written statement from them so I get more of the story. That way, once I do send something like this over, whatever I get, I can put on paper and I send it over to the prosecutor. If they think there's probable cause to go forward, and then a magistrate thinks that, then it gets signed. If they don't, then I can only present what facts I have.
Okay. At your precinct, you guys have a warrant prosecutor? Yes, typically I remember from back in the day, you now like they have assistant prosecutors available so that they can sign off and stuff like that. And that's relevant. He's part of
And also, I'm gonna check the notes here. Other than you establishing in your argument that there was no warrant signed, what is your purpose?
I'm trying to show how his investigation came forward. I know I've read things concerning the Fourth Amendment. Fruits gathered after an illegal search and seizure are admissible in court. And I'm trying to establish that. I remember from back in the day that they had prosecutors readily available that could sign off on stuff like that. The prosecutor didn't even sign off on it. And I'm just trying to.
I'm sustaining the objection. It's not relevant right now. You can put that in a motion if it gets filed over.
Are you aware that Mr. McCreary, past and present, has come into your precinct, made complaints against your officer there?
Your brother Norman?
No, me, Colonel Michael McCreary, ill.
I'm gonna object. Oh, it's relevant.
It's for purposes of impeachment, Judge. That's how it's
Everything
relevant.
you keep saying is for impeachment.
People versus Stanaway. Stanaway law.
It does not say you can impeach on anything. I know that case law does not say that. You can say anything if it's impeachment. That's not how impeachment works.
Well, I'm trying to show and establish retaliation by DP.
Okay.
Because of numerous complaints against them, because of recording them, putting them on YouTube, where they told an officer to break in the house.
On the stand, doesn't know your brother, apparently, until this case is filed, and doesn't know you. So can we move on to something else about what happened on the date and time of the investigation regarding you and your brother's complaint?
I mean, yeah, I objected again to this court's handling of this case. I had something in mind, but you proved me off. This gentleman here. Okay. Did you ever look at Mr. McCreary's picture? It was stated in here that you showed, or one of your officers showed Mr. McCreary, my brother Norman McCreary, picture. Is that correct?
Correct.
Do you know what picture it is? Do you have a copy of that picture here today in court? Because that wasn't in the discovery.
It's included in my packet. It's over the APA's office. It's the Michigan SOS picture provided to me by the law enforcement information that we call lien.
And what came up in the lien? My driver's license, or what came up?
The Michigan SOS picture, yes.
Okay. All right. Your Honor, can I have the court officer show the prosecution's witness something?
Your Honor, it's your witness.
No, I have.
What is it? I don't even know what you're trying to do.
I'm laying the foundation. He's keep trying to shoot
What are
me
you trying
down.
to do?
I mean, I'm trying to figure out how he came in contact with me, how he came about. He just stated in here, so I'm gonna show my driver's license. Okay. Did you ever look at Mr. McCreary? And I object, right, to the denial of that. Did you ever look at Mr. McCreary's driver's license?
His actual license? No.
Which Mr. McCreary?
Me, I'm talking about me when I addressed me. Well, Colonel McCreary. Did you ever look at Colonel McCreary's driver's license when you did the investigation?
Physical license, the one that's in your wallet? No.
Okay, but what I'm saying is in the system.
It wouldn't be your license, it would be the picture provided by lien.
The picture by lien. Oh, okay. Lien system. I didn't. Okay, so I believe on the paperwork it says a CTN. What is that? A CTN, sir?
CTN.
A CTN, like on judgments, warrants, things of that nature, it says CTN, then it has ORI.
You asking me what a CTN is?
Yes.
So that's gonna be generated by the system.
No, I'm saying you give me a breakdown and define what CTN.
It's not something I deal with on my end.
Okay, may the people, attorney, since he always wants to object, could you tell me what a CTN means, sir? And help you with it?
I'm not testifying.
Okay, so you don't know the CTN. Did you know that a CTN is?
I don't have objective, no.
I haven't finished.
I don't see the relevancy of the CTN.
I'm just saying is I haven't finished my line of questioning. for him
Well,
to
I
object.
can't imagine what a CTN has to do.
Well, it's a
Assault
cargo
with
tracking
intent to
note.
murder. I'm sorry, what?
It's a cargo tracking note.
Okay, and that's not relevant today. So next question, I know you objected to that as well. We'll place on the record, this
So-
is objection to my CTN, he's defending that objection. Go ahead.
So you stated that you looked at my ID and whatever else in the link says.
Right.
Okay. Did you know, that me, Colonel Michael McCurry, reserved his rights not to be, governed or controlled by city, county, state, federal officials? Well, I mean, it's relevant. See, I tried to establish
It's
relevancy.
relevant to you, Mr. Curry, but it's not relevant to the case here.
Well, it's relevant because I'm not the strong judge. I'm not
Okay.
doing business with the corporation. This is what I've been trying to
And
establish,
you
but
have-
you're limiting my
I am.
defense. My
I am.
defense, Judge.
I am.
What about the motion so far as additional discovery to impeach him for?
What did I say?
I'm not gonna help you.
What did I say?
And I have those
What
rights.
did I say?
You said after the fact, it was bound over, you will sign a discovery order, but I'm entitled to that to do a proper, defense.
That's what I said, that's not gonna change.
Well, under federal law, I have a right to present a defense and this court is denying it. So
No, I did
don't-
not deny you at all, we've been here for over an hour, and you've been presenting things to us.
Okay, I can't question this guy because, this officer, because the court, the prosecutor keeps objecting, I'm being denied the right.
Well, maybe because you're not that great at
I mean,
cross-examining.
I'm very well, I have a right
You're not
to,
that well versed with the court rules or evidence.
well, I fight with constitutional law, which you have ignored, which you have.
Definitely fight with it,
Well, I'm just saying, under the
But-
Constitution, this court is bound by that.
I know what I'm about by. Do you have any other questions?
I mean, I'm being denied, so I would just object, and then I would, once, if it's bound over, I would do a motion for a remand back to this court in front of the circuit court with paperwork. And, like I said, I'm in the process, I should be taking that down in this coming week to the federal court. And I would like also to have this case removed to the federal court.
Do you have
under
any more
removal statute.
questions of the witness?
I mean, I can't
Just a
question
yes
them.
or no?
No, I can't because I'm
Okay.
being denied.
Okay, any cross?
No, Your Honor.
Okay.
Thank you, Your Honor.
Any other witnesses or defense?
Yes, I would like to call the other witnesses listed on the paperwork.
And what did I say about that?
And you deny it.
I said you did not subpoena them or ask the prosecutor to make it available for you to interview them for the exam today. So they're not here, so you're not prepared to call them.
Well, I just want to say this for the record, so just in case the higher court looks down the line at this.
Sure.
And like I tried to explain to the court, it was my intention based on the reading of the rule in the case law. It says even where you cannot show actual bias in the Supreme Court, that you would be removed and then I would have time to prepare these motions and documents. And I'm being railroaded by this court as well as the people who just admitted they have no warrants, they had no evidence. I mean,
The
what
higher
is?
court, the higher court, that's what, I'm at the district court level, so that's what the higher courts are for, so they can address.
But is, okay, but may I respond to say something? Now, the law is clear. I mean, you took an oath under Article 6, Section 2.
Mr. McCreary, I don't want to hear about it unless it's about your argument in response to people resting after they rest. Well, actually, they rested already. And you don't have any other witnesses present.
Well, I mean, I'm denying my witnesses.
You never
And
denied. You were never denied. You had a witness list, you didn't contact, you didn't ask the prosecutors to provide
I didn't think
them, or
this-
make them available for you to interview, or contact them, or subpoena them, to come to them. This has been adjourned several times, you have plenty of time to do so, I've let you go to the library to research, I've let you even go to the court to file a lien against my house.
I'm waiting.
I've done way more than I should have allowed you to do, so I am not going to adjourn this or provide discovery request to you or grant that based off of you not being prepared today to call witnesses that were provided to you on the witness list. So are there any other witnesses present today that you would like to call?
Well, I would like to respond if I may.
Yes or
Because
no?
I mean, you say I can't because I'm being denied.
Okay, so you don't have any other witnesses?
I mean, I have them. Yes, my brother Charles McCreary. I would like these police officers to be brought into court. Robert Vane, Diana Gerald. I have many other people that are willing to come into court and testify. And I'm being denied that. I would like to just again clarify for the record that I didn't think that you would be moving forward because I was just in a court proceeding with Judge, what's her name? Where she denied the motion, then she sent it to the chief judge. Because from my understanding that if the judge grants it or denies it, then they have to send it to the chief judge. You never ruled granting or denying the motion per the court rule.
You accuse me of being biased, so why would I make a decision?
I mean, well, what I'm saying is you.
Why would I make a decision on
What I'm saying
something
so
where you're
far.
saying that I'm biased to you?
Well, I'm about to answer this. Like if you would have said denied, then you had to send it to the chief judge. If you would have granted it, okay, it would have been sent for a blind draw. Per the rules and under people versus.
This is blind draw, this is not trial. This is the exam stage,
I understand.
okay? So you don't have any further witnesses.
Well, I do.
Today was an exam,
I mean, I wanted them at the
they're
exam.
just not here because you didn't subpoena them, ask them to come, or ask the prosecutor to make them available. So I'll be in.
Thank you, Your Honor. Your Honor, the people move, bind over the defendant on all charges. It's a matter of, it's a question of fact. We have one witness, that says that the defendant took shots at him, put him in fear for his life. Defendant is a felon, convicted felon, and therefore he's not allowed to have firearms or ammunition. He attacked his own brother with bricks and a rifle. And there has been no official testimony of him not doing it, other than the defendant during his objections or arguments or whatever they are, saying that I didn't commit a crime. It's a question of fact. It should be found over. And testimony was that it occurred in the city of Detroit, County of Wayne, so this court definitely has the jurisdiction under the court rules and the law to hear this and bind this over. And you know, he took aim at his own brother and shot at him. So we asked for a bind over on all charges.
First and foremost, I would like to object because by the officer on the mission and the prosecutor knows fully well, there's no evidence, Judge. Not just that, the witness lying here in court today, and he's not credible. He stated that he never forged any signatures or whatever else. And I have evidence to show the opposite, that he committed perjury right here on the stand. Also, the burden is on the prosecutor. I'm innocent until proven guilty per administration of justice. Again, I adamantly object and deny these allegations. He's stating that ammunition, all that, where's the pictures of the guns, Judge? Like I stated before, where's the evidence at? Except my brother who has lied in the past and he has a dishonest history and he has a history of theft. And let me finish. I didn't object to, I didn't interrupt him. I'm giving my code. I didn't interrupt him.
I'm just gonna object.
Just object.
That's fine. I didn't say that when he was talking.
We've been talking all day.
I'm gonna object because these are quoting facts that you tried to get into evidence and they're not in it.
Mr. Salaki, I know the difference.
Okay.
Objection on the record. Mr. Terry.
Okay. Under Opera versus United States, 348 U.S. 84, the Supreme Court held an accused extrajudicial admissions of essential facts or elements of the crime made subsequent to the crime are of the same character as confessions and cooperation by independent evidence is required. A, the requirement of cooperation applies to exculpatory statements to the same extent that it applies to incriminatory statements. The jury's finding in this case from the admissions of the essential facts together with all other evidence that the guilt of the petitioner had been established beyond a reasonable doubt is supported by substantial evidence.
Beyond a reasonable doubt is at the trial.
Okay, and I'm just reading this, like, to prove that the cooperative evidence need not be sufficiently independent of the statements to establish the corpus delicti. It is sufficient if the cooperation supports the essential facts admitted sufficiently to justify a jury inference of their truth, but those facts plus the other evidence must be sufficient to find guilt beyond a reasonable doubt. Now, I understand that this is just probable cause, but why waste the state's money and continue this vindictive prosecution to proceed, Your Honor? They've admitted that they have no evidence. They've admitted that they have nothing but this man's word of mouth, who is in the community is known as a liar and a perjurer. And I wanted to call Chief Judge Burton in, who's in Wayne County 3rd Circuit Court, to establish this, that he lied under oath, that he committed felonies. I mean, the prosecutor's office committed felonies, their witnesses committed felonies. I mean, it's factual. So at this juncture.
You can find all of that at the trial, at the 3rd Circuit.
But again, I would like to object to this court's hearing of this exam for judicial bias, because under Kane versus MPOC, it says that even if I can show bias, justice teaches that the judge should recuse themselves because you have been the target of criticism and so on and so forth.
Only by you.
Okay, but what I'm saying is, and I've been arguing the law, and the court overruled federal law, which states.
Some of it's bad law.
Okay, well, I've researched it. I've researched it and I've shepherdized it, and it's still good law.
Okay, so, okay. Mr. McCurry, you have made your argument, objected for the record. And would you like to preserve that? Argument that there's no evidence presented today. What the court has to remind defense of is that testimony is evidence, whether you like it or not. I do believe that witness, Mr. Norman McCurry, was credible. And the burden of proof is on them. And they have to show at the probable cause standard. First, assault and attempted murder, that the defendant tried to physically injure a person, another person. There's testimony that the defendant, Mr. McCurry, tried to by not only aiming but also firing a gun at the complaining witness. Second, that when the defendant committed that assault, he had the ability to cause injury. In this case, he did have the ability. That was a deadly weapon that would definitely cause injury. And third, that the defendant intended to kill the person he assaulted, and the circumstances did not legally excuse or produce the crime. That would be a question of fact, the trier of fact as to the intent of what Mr. McCurry was doing. Pointing the gun, I do believe in the probable cause standard, pointing the gun and shooting someone shows intent to kill. As far as the remaining charges, assault with intent to break body harm less than murder is lesser included, satisfied by the evidence of testimony. The count 3 firearms possession by the felon has been established in Exhibit 1, in which Mr. McCurry was not eligible to be in possession of a firearm, as well as count 4 ammunition in the weapon satisfies count 4 ammunition possession by a felon, and count 5 assault with dangerous weapon on its assault has been satisfied based on the same testimony from the complaining witness and of course the 4 accompanying weapons felony firearm charges. So Mr. McCurry, you're going to be bound over to 3rd Circuit Court, Framework of Hall of Justice for your arraignment information date of June 29th at 9:00 a.m. I do not know if it'll be on Zoom or if it'll be in person. It depends on which judge you draw. Anything else from either party?
No, nothing from the people, Your Honor.
Mr. McCreary, other than your objections?
I would like to, place my objections on the record because throughout this entire proceeding, I feel that this court has been biased, when it comes to rulings. They've even allowed this, prosecutor to, use state law to supersede federal law, as stated in, Cohen's versus Virginia, that is considered treason against the United States Constitution. These are landmark cases. And also, you know, the witness lied under oath by stating he didn't do this, this, and that. And I mean, under substantive due process, the U.S. Supreme Court held that no matter what rules you create, you must use fundamental fairness. Well, I mean, you asked me to have anything else to say.
Anything else, anything additional?
Well, I object. I mean, I'll just let you buy me over. And can I say one more thing? Again, like I challenged jurisdiction before testimony was even brought in.
And I deny it.
And, okay, but the law
Do you want the
mandated.
discovery order signed? Before I buy you over?
Yeah.
Okay, and what was it specifically that you?
I
wanted
mean,
for?
I would like all the officers, background history, Kim Worthy's. I would like the individuals here today because it shows a pattern in history of felonies being committed against citizens.
So what I'll do is I'll sign this discovery right here, and if you want to expand it, with the new judges you get across the Third Circuit, you can ask for those additional things like Kim Worthy's background. I'm not dealing with that. Short order. I don't even know what that.
Well, what I'm saying is so far she's the chief officer of the county.
Yes.
And everything.
And I am not going to do that.
And everything that her subordinates
I'm
do.
signing a normal
Well, what about the
court
bond?
scale certified discovery order for you to make sure that you have everything in any video. It was mentioned that there was video possibly at the police station. This will get you that into the goods, okay?
Okay, well, what about the bond? I mean, I didn't run, I'm not a runner. Why do you got this tether on me? I mean, I can't get out and work like I need to. I can't get out and move. I mean, I don't know what my brothers say. I'm not trying to do that. This is a complete fabrication.
I give you a lot of leeway.
Pardon?
I give you a lot of leeway.
I
I'm going to
mean,
continue by.
I have a right to live. And my liberty is being restrained by these people who committed felonies.
And the other option is within the Wayne County Jail with assault and attempted murder charges. 629 at 9 o'clock, okay? Attorney Segura. Good morning. Okay, we're on the record with the people of the state of Michigan versus Ms. Hill, 2258352. Ms. Hill is charged with one count of assault with dangerous weapon, felony assault. Also, Ms. Hill is charged on case 2258224 with one count of assault with dangerous weapon, felony assault. Both statutory appearances.
Alexander Kirker on behalf of the people, P86282.
Melissa Segura with the Neighborhood Defender Service, on behalf of Ms. Hill, P86432. Ms. Hill, would you please state your full name for the record?
Caleb Denise Hill. Okay, we have two exams set today. How are we moving forward?
Your Honor, at this time, the people are not prepared as the complaining witness is not present. I've spoken to both officer in charges, who have been unable to subpoena the complaining witness. There's one listed phone number, but it no longer works.
Yes, Your Honor, we would move to dismiss on both matters, Your Honor.
Okay, I will dismiss without prejudice. The time is 11:51 and the people cannot move forward. The case has been dismissed.
Thank you, Your Honor. And may I address, Ms. Hill has a tether. Could we please get in order to remove that tether, please? And if the court could, send me a copy of that order so I can provide that to Ms. Hill as well.
I will.
Thank you, Your Honor.
Why is it that you have to have an order? I don't understand why the dismissal, they don't just remove that.
Sometimes it takes a while, Your Honor, for them to receive it, and so if Ms. Hill goes there, the tether unit is not very, receptive to phone calls. It's very hard to get in touch with them, so it's just nice to have that order so we can just show them, you know, promptly.
Okay, it's done.
Thank you.
Thanks.
Oh, okay, perfect, thank you.
I already signed.
Thank you.
Look, let's just get through Randolph.
I'll bring it out.
Okay, thank you. I hope you have a better
This is case 2357116, the people of the state of Michigan versus Monique Randolph, charged with assault with dangerous weapon, felonious assault, and weapons stun firearms set for the gas day appearances.
Everyone's walking P54828, appearing on behalf of the people.
Good afternoon, Your Honor. Matthew Forrest, P73168, appearing on behalf of Monique Randolph, who's present standing behind.
Ms. Randolph, can you state your name, please? Monique Randolph. Have any preliminary matters?
No preliminary matters from the people.
Defense would move this request for any witnesses.
Does anyone on Zoom or YouTube who may be a witness of this case and or testifying, now time for you to log off, saying in the courtroom, if there's anyone who may testify as a witness on this case, now is your time to exit the courtroom. Please log in.
I call, people call Mr. Kendrick Jones. So you, of course, where he's not.
You know how to spell and say your name, Mr. Jones, come on over to this young lady and say and spell your name to her, your first and your last. Come on, come through.
Your first name, K. E. M. B. R. J. Last name, J.
Turn and talk to the judge. Good morning. You're gonna swear you in, okay? So you're gonna raise your hand, the right hand. You swear to tell the truth, the whole truth, and nothing but the truth. So, the door opens right here, Mr. Jones. Go ahead and have a seat. And we're gonna put the microphone in your lap, make sure you speak in the microphone. And if you don't understand the question or you can't hear it, just say that, okay? And then we'll repeat, or the words you repeat it, explain to you the question, okay?
Young man, can you state your name for the record, please? Can you state, what is your name?
Kendrick
Last name?
Jones.
Thank you. And, did this incident occur on May 27th this year?
I think so.
Where did it occur at?
Mr. Jones, you can pull the microphone just a little bit back from you so it won't make that noise. Okay, try that.
And where is this park? Where is this park located at?
Across the street from my house,
And what street do you live on?
Trinity Street.
And is Trinity Street in the city of Detroit?
Yes.
Okay, what were you doing?
I was on the playground and I told this little boy kept on messing with me. So I said, leave me alone. And then he got his big brothers and then the mom left.
Okay. When you say messing with you, what do you mean?
He kept on bothering me. He kept on calling me names.
And then he got his big brother, and who else?
His mom.
Is his mom in the courtroom today?
Yes.
Could you tell us where she's at and maybe a piece of clothing that she may be wearing?
She's in the front of the room and she's wearing a pink shirt.
Okay, let the record reflect that Mr. Jones has identified the defendant. What occurred next? What happened next?
After that, the mom left. She came back with a gun.
Okay, do you know where she went?
No,
Okay. And once she came back, what did she do?
she pulled out the gun out of her car.
Okay, so she was in her car? What kind of car was it?
It was a small black car.
Did she do anything after that?
Well, no. Well, she pointed it at me, says something on her breath.
I'm sorry, I couldn't hear that last part.
She pointed it at me and said something under her breath.
And when she pointed at you, how did that make you feel?
Scared.
Did you see her before that day?
No.
After she pointed the gun at you, what happened?
I went home.
And nothing further.
Ross?
Good afternoon, Mr. Jones.
Good afternoon.
I'm just gonna have a couple questions for you, okay? And if at any time you don't understand anything I'm saying or the question, just ask me to repeat it or rephrase it, okay? Is that a yes?
Yes.
And if you give a response to a question that I've asked, I'll assume that that's a truthful response. Is that fair?
Yes.
Now, you indicated that you were at the park on May 27th, you think, is that right?
Yes.
And who were you there with?
My friends.
What are their names?
I don't kind of know because I just met them like a few days ago.
Okay, a few days prior to May 27th.
Yes.
And you indicated that when you were playing on the playground area, is that right?
Yes.
And little boy started messing with you.
Yes.
You know how old that boy was?
No.
At some point, the little boy went and got his brothers, is that right?
Yes.
Now, this playground area, other than you, how many friends were you with?
3.
So 4 total, you and 3 other friends? So yeah,
Yes.
this little boy that was messing with you, how many brothers did you have?
2.
So it's 3 of them?
Yeah.
And was anyone else in this playground area?
Me and my friend.
Right, other than you and your friends and this little boy and his brother, were there any other kids there?
Yes.
About how many?
Like, I don't even know the count.
More than 5?
Yeah.
More than 10? But yeah,
Yes.
more than 15?
No.
Okay, so somewhere between 10 and 15?
No.
More than 10, but less than 15?
I don't understand.
I'm just trying to figure out how many people were in this playground area at that time.
The boys was with their cousin. I think that was their cousin.
Right, let me ask you this, other than you and your group of friends and this little boy and his brothers or cousins, were there any other kids around?
Yes.
You indicated somewhere more than 10 other kids?
No, it was like 2 other kids.
And were there any adults around?
Except but the person, no. Well, it was, they were by the other part of the playground.
Okay, so they were nearby?
Yes.
How many adults were around?
Like 2.
Were there other adults in this park within that you could see, maybe not in the immediate playground area, but somewhere else in the park you could see?
Yeah.
Do you know how many? You had to guess.
Like 3. It was like 2 parts by each other, and I went to the bigger one.
So there were at least 5 adults that you could see in the area.
Yes,
Now, at some point, you indicated that the little boy that was messing with you went and got his brothers. Is that true?
yes,
And then the little boy's mother came over, is that right?
yes.
At that point, did the mother say anything to you?
I don't know what she said, but she said something.
She said something, you just don't know what she said?
Yes,
And it was at that point that the mother then went to her car, is that right?
yes.
And where did you see the mother go to the car?
Yes.
And where did she go inside the car?
Yes.
Where inside?
The front seat.
And how far was this car from where you were on the playground?
It was like by the trash cans, by the trees.
Was it far or close by?
Close.
And you indicated that the mother then came back to the playground area, is that right?
Yes.
So the mother walked from her car back over to the playground? And at this time, these adults that you said that you saw, are they still in the area?
Excuse me.
The adult, you said that you saw some adults in the area by the playground, right?
Yeah.
When the mother came walking back from her car, were those adults still around?
Well, the ones at the other part, they left, but the 3, they were still there.
Okay. And you indicated that the mother had a gun?
Yes.
And did you tell the police that that was a black gun?
Yes.
And that is true?
Yes.
You said that the mother pointed this gun at you?
Yes.
How far was the mother from you? How far was the mother from you when the gun?
I don't know by inches, but she was by her car, that's all right.
So she was by her car when this took place?
Yes.
Within arm's reach of her car?
Hmm.
Like how close to her car was she?
Like touching distance.
Okay. And you were in the playground area?
Yes.
Is there a piece of equipment that you remember you were standing by when this happened?
I was standing on the merry-go-round.
Was anyone else nearby you at that time?
Yeah, there was this other boy, I don't know him. He was the son of one of the other moms.
Was the little boy, could you tell if the little boy was friends with the little boy that was, like you said, messing with you?
Yes.
He was?
No.
Oh, he was separate group?
Yeah.
After this happened, or how long did this happen? How long was the gun pointed at?
Just like a few seconds.
Few seconds? Yeah. Did you tell where, was it pointed at your body, or where it was pointed?
My body.
And was anything said by the mother at this time?
No. She said something under her breath, but I couldn't hear her.
At that time when she was pointing the gun, she said something under her breath? So yeah?
Yes.
But you don't know what was said?
Yes, I don't know what she said.
You said that this occurred for a few seconds and then it stopped, right? So yeah?
Yes.
What did the mother do at that point, once it stopped?
She left the car and she went by where she was having her career life.
Was that close by to the playground?
No, by the park, no, the park by her car.
Where she was having the barbecue was by her car?
Yeah.
Were there other adults in that area?
Yes.
You could see them? And when I say that area, I mean where she was having the barbecue?
Yes.
How many adults were there?
I don't know.
More than 2?
Yes.
What did you do next?
I don't know.
And you live across the street from the park?
Pardon me?
You live across the street from the park?
Yes.
And you went home, you made contact with your father, is that right?
Yes.
And you told him what happened? Said yes?
Yes.
And then your father called the police?
Yes.
And were you there when your father called the police?
Yes.
Did your father tell the police what you told him?
No, I don't.
Okay, so when he called the police, he put you on the phone?
No. What happened was he told the police what happened.
Right, on the phone, right?
Yeah.
And did he tell the police what you told him?
Yes.
And you heard him tell the police what happened?
Yes.
And was everything he told the police accurate?
Yes.
Did you tell your father that the mother had fired the gun?
No.
You never told him that?
I never told him that she fired the gun.
So if your father told the police that would be inaccurate, that would not be right, correct? Thank you, Judge.
Redirect. No further questions. Mr. Jones? All set, okay? So you can, read it and read it out. Any other witnesses?
Yes, Your Honor, people call Officer Anthony. Yes.
Step up to the court reporter and say and spell your name, please.
Never ready to slide.
Thank you, Your Honor. Sir, can you state your name and occupation for the record, please?
My name is Anthony Tias. My occupation is a police officer.
And who are you a police officer with? How long have you been with them?
I'm a police officer with the Detroit Police Department, and I've been there for coming up 2.5 years.
Were you on duty May 27th of this year?
Yes, sir.
And were you on duty in the area, I believe it's Detroit Road in
Spinoza.
Thank you. And that's in the city of Detroit County, Horny?
Yes, sir.
What were you doing in that area?
I was called there for an aggravated assault, police assault incident.
And did you take a statement from Kendrick Jones?
Yes, sir.
And did that statement lead you to investigate the situation?
Yes, sir.
And what was that situation?
They stated that
I'm just asking, not for the truth of the matter, but why he was investigating.
I don't know who they would be that he's speaking But if it's not Mr. Jones, then it would be hearsay, unless it's an exception.
Okay, I'll concede that. For lack of a better term. So your statement from Kendrick Jones, what did he say?
The victim stated that the offender pointed a weapon at him, during some sort of disagreement on the playground.
And did he give you a description of the offender?
At the time, he pointed out, the offender that she was wearing like a bright colored, I wouldn't say uniform, but bright colored clothing, and, he pointed in her direction. And he also described the vehicle that, she retrieved the weapon from, prior to the assault.
What type of vehicle was that? Do you recall?
I believe it was a Ford Fusion.
Color and size?
I don't remember the color, but it's a smaller sedan.
And did you have a conversation with the offender?
Yes, sir.
And is she in the courtroom today?
Yes, sir.
Could you give us her location and describe a piece of clothing that she may be wearing?
She's sitting directly behind you, wearing a pink shirt.
Let the record reflect that the officer has identified the defendant. Did you ask if she had a weapon?
Yes, sir.
What was her answer?
She said no.
What did you do next?
Gathered whatever story she told me, and then searched the vehicle that was described to me by the victim.
And did you find anything in that vehicle?
Yes, sir.
I'm sorry, vehicle.
Yes, sir.
What did you find?
I found a unloaded hanger inside the trunk of the vehicle.
What type of weapon was that?
I believe it was a 9mm. I don't recall like the exact make or model, but it was a 9mm handgun.
And what occurred next?
My partner also searched the vehicle with me. He recovered one loaded magazine and one unloaded magazine from the front of the vehicle. We then reconvened and decided to arrest the offender based on probable cause.
And nothing further.
Officer TSU, been a police officer for 2.5 years in the city of Detroit, is that correct?
Yes, sir.
And you've been trained by the Detroit Police Department on how to conduct an investigation once you receive a call to go to a certain scene, is that correct?
Yes, sir.
Okay, and what are you tasked with doing when you receive a call such as this for upon arrival?
Just get the stories from both sides and then determine if an arrest needs to be made.
And how do you make that?
Just based on the statements, all the context, all the totality of circumstances that are presented to me.
So it's your goal, correct, to gather as much information as possible upon arrival to the scene so that you can make a decision on how the scene is to be resolved, right?
I guess so, yeah.
And when you arrived on scene, let me ask you this, the run that you received was for a aggravated assault or felonious assault, is that what you stated?
Yeah, if I recall correctly, I think so.
And was there any indication in the run that shots were fired?
I don't recall, but I know at the time, it was a very hectic day in Rouge Park. There was a lot of shots fired in that area specifically going on and in the rest of the park. So I don't know if there was something directly in conjunction with this incident or if it was something in conjunction with something else going on in the park at the time.
Okay, so on May 27th of 2023, there were multiple reports of shots fired at Rouge Park, is that correct?
Yes, sir.
And those would be separate from this particular incident, is that correct?
I have no idea. It could be. I don't have a shot spotter app. I have no idea of number.
Did you receive any information from anyone on scene that shots were fired in this particular incident?
Can I refer to my report, please?
Sure, that will refresh your recollection.
Please.
Yeah, so
Yes.
Thank you, sir.
I handed you a 2-page document. You recognize that?
Yes, sir.
What is that?
It's my police report.
From this particular incident?
Yes, sir. According to my police report, I did not say that there was any shots fired in conjunction with this. From what I heard from anybody I spoke to last week.
That's the report.
Yes.
I direct you to the second paragraph that begins upon arrival. Review that.
Okay. That refreshes my recollection. Yeah, the reporting party, the victim's father stated that. But I didn't hear that from the victim himself.
All right, so the complaining witness's father told you that shots were fired during this incident?
Yeah.
So you had an opportunity to, upon arrival on scene, talk to the complaining witness's father, is that right?
Yeah, he was the one who initially called us. We initially came in contact with him.
And what was his name?
Dietrich Jones.
And who else did you speak with upon arrival?
The victim, Hendrik Jones.
Anyone else?
The offender.
Anyone else?
No, sir, not that I recall.
Now, this area that you were dispatched to, it's in Rouge Park, is that correct?
Yes, sir.
And the part of the park that you arrived, is that near, or where is the playground area where this allegedly took place in relation to where you were?
If I were to go off my recollection, it'd probably be I'd say approximately 500 feet to 1,000 feet on the northwest corner of intersection at Joy Road.
And you indicated that the complainant pointed out Miss Randolph on scene, is that true?
Yes, sir.
And she was in an area with a group of other people barbecuing, correct?
Yes, sir.
And do you recall how many people were at that barbecue?
Probably go based on memory, probably like no more than 20. Most of them were children though.
Were there any adults as part of that 20 people?
Yes.
Approximately how many?
I couldn't tell you a straightforward answer. I don't know.
More than 5?
Possibly.
And this area where Miss Randolph was having this barbecue, how far is that from where the playground is?
It's directly next, like I'd say it's within like a couple 100 feet.
So if you were standing at this barbecue area, one would be able to see the
Yes.
playground. There's nothing obstructing the view.
Maybe a tree or two, but not really.
Did you speak to any of the adults that were part of that barbecue?
Based on my recollection, I spoke with the offender, and I think it was her husband or significant other or boyfriend maybe.
And did you receive any information about this incident from the boyfriend or husband?
Not that I recall that was relevant to my police report.
Because in fact, the boyfriend or husband told you that nothing ever happened. Right?
Objection, hearsay.
Judge, I'm asking if you received information, and if he did, why sign his report, and if he didn't. So.
Would be hearsay as far as what the boyfriend may have said. Officer saying he didn't hear anything that was relevant.
All right. Let me ask you this. Did you receive any information from the boyfriend or husband that corroborated the complaining witness's version of events?
Anything that I heard from him was relevant to my investigation. So that's why it's not in the report.
So he was talking to you about something other than the events that occurred that day?
I don't recall what he said to me.
Did you put in your report that you spoke to that person?
No, because it was relevant to what he was saying to me.
Did you speak to anyone else in that group at that barbecue?
No.
So the only information that you received about this incident was from the complainant, Mr. Jones, right?
From the complainant and the complainant's father.
But the father wasn't, he indicated he wasn't present, right?
I believe so, that's what he stated.
Now, did you obtain a search warrant to search the vehicle?
No, sir.
Did you have any indication as to what, let me ask you this, you indicated that you recovered a firearm from the vehicle, is that right?
Yes, sir.
And where did you recover that firearm from?
The trunk of the vehicle.
And was the firearm in any sort of case or anything like that?
It was in an unlocked case.
An unlocked gun case?
Yes.
In the trunk of the vehicle?
Yes.
Can you describe the weapon that you recovered?
I don't remember the exact make and model, but it was like green and tan, semi-automatic 9mm.
Not a black. And your basis for searching that car was what?
Probable cause.
Based on what?
The statements from the victim.
And you already indicated that you did not obtain or attempt to obtain any other information regarding the vehicle from anyone else present, right?
No, sir.
So just based on the victim's statement alone is what caused you to search the vehicle without a warrant, is that right?
I searched the vehicle based on the victim's statements. He pointed out the vehicle, he identified the offender. That's why the search was conducted.
Correct, based on solely the victim's statement to you, why you searched the vehicle is my question.
I guess, yeah.
Did you recover any spent shell casings?
No, sir.
Other than you and your partner, did anyone else from the Detroit Police Department arrive at this scene?
There was another unit another 2 units that came on scene.
So how many total police officers are about?
Including myself, my partner, 6.
And were they on scene before you searched the vehicle?
Yes.
All right. Did you see them speaking to any other adults at the location?
I don't recall.
You don't recall seeing them speaking to other adults?
I don't recall. I don't remember.
Was any other adults on scene attempting to talk to you or other officers?
I don't recall, just based on memory.
No regret, no regret, no regret.
Any other witnesses for people?
No other witnesses, Your Honor.
Okay, you can argue as soon as you step out of the courtroom.
Your Honor, people request that the defendant be bound over, excuse me, on both counts, assault with a dangerous weapon, felonious assault, and weapons, felony firearm, reserve argument.
Judge, we would object to the bind over on the basis that Officer Tias performed an illegal search of the vehicle in question here. In order to establish probable cause, there has to be substantial evidence that there's a fair probability that evidence of the crime will be found at the location of the search. Officer Tias indicated to this court that his sole basis for searching the vehicle was the statement from Mr. Jones. And if we were to follow this rationale, anytime anyone on the street makes a simple allegation to a police officer that something happened in connection with a vehicle, would then give the police authority to search that person's vehicle without anything else. There's been nothing else, nothing to corroborate any of the statements that Mr. Jones made. No other witnesses from that event were talked to by the police, apparently. No one came to court here today to corroborate any of that. So without some sort of other indication that Ms. Randolph had any connection to this vehicle and that there was a evidence of a crime in that vehicle, that search of that vehicle was illegal, and anything recovered from that search should be suppressed. And without a firearm as evidence in this case, there's no evidence that a firearm was pointed at Mr. Jones, especially as it relates to count 2, the felony firearm, where they must prove that an actual firearm was used. So based on that, we would ask the court to dismiss.
Yeah, this is a probable cause here, as you know. And the officer searched the vehicle based on the testimony which we heard from Mr. Jones, that the defendant went to that car and retrieved the gun and pointed at him. That is enough. Mr. Jones has testified that the gun was pointed at him and it actually scared him. That's a question of fact for the jury, or excuse me, trier of fact. This is a probable cause hearing. The police officers had probable cause to search that vehicle, and even so, Mr. Jones's testimony, that's an assault with a dangerous weapon, is enough to probable cause. And dangerous weapon being a gun, he identified that as being that it was a weapon, a pistol. So there's definitely enough, our position that there's not probable cause to find this over, and we ask that both charges, I'll know we're on both charges.
There has been probable cause established for both charges. You have to show for felonious assault first that the defendant either attempted to commit a battery on Mr. Jones, or in this case, did an act that would cause a reasonable person to fear or apprehend an immediate battery. I believe that was established in Mr. Jones' testimony as he testified that the gun was pointed at him by the defendant, and that would cause a reasonable person to fear or apprehend an immediate battery. Second, that the defendant intended either to injure Mr. Jones or to make Mr. Jones reasonably fear an immediate battery. I believe he will be reasonably in fear from a gun being pointed. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought she had the ability. I believe all three of those apply. She had the ability with that weapon, appeared to have the ability, and thought she had the ability. Fourth, that the defendant committed the assault with a dangerous weapon. Fourth, we brought up the point that the gun it was not established in the testimony of Mr. Jones that that needed to be a real gun. However, based off of Officer's testimony that along with Mr. Jones' testimony, Mr. Jones stated that he saw the defendant go to the car and retrieve a gun, and Officer then arrived on the scene and spoke to Mr. Jones. And Mr. Jones pointed out the vehicle that he saw the defendant retrieve the gun from. Although the gun was not the same color as described between Mr. Jones and between Officer Tias, there was an actual gun recovered from that vehicle from the trunk. And also, I know Attorney Burton brought up the issue of the search of the vehicle. I do think that there was reasonable suspicion and enough facts for Mr. Jones, based off of what he stated to Officer Tias, to believe that there was a gun in that vehicle, a dangerous weapon. With him describing that car and describing the defendant going into the car, retrieving that gun, and then later explain all that to the officer. So I will bind you over, Ms. Randolph. You are not in custody. So your Randolph information date will be June 29th at 9:05 a.m. And bond is continued.
May I address bond?
Sure.
Judge, as part of Ms. Randolph's bond, she's on a GPS tether. I would ask the court to remove that condition of bond. There's no indication that the parties here know each other, live in the same area, anything like that. Ms. Randolph has appeared in court, she's been in close communication with me. I don't think that there's any necessity for a tether at this point. I ask that you.
Anything from the people?
Your Honor, the charges are quite serious, and we objected to found more reason to remove the tether.
Judge, just because the prosecutor claims the charges are serious, the purpose of bond is to ensure the safety of the community and return to court. I don't believe that Ms. Randolph has any assault history. She has appeared in court. There's just no need for a tether. She doesn't know these people, doesn't know where they live. So it's not like there's going to be any contact or any.
My issue is more concerned with the community. My concern with the community. The allegations here in the testimony show that Ms. Randolph brought a gun to a park where kids are playing. I don't see any cases history, but what I heard today, I don't think I feel comfortable removing that tether. I'm going to keep an eye out for a DSU report if you want.
Yes, please.